You told the public, you said you will establish the Commission of Inquiry. What's your problem? You said you have no problem with the Commission of Inquiry. Establish it. And the point I simply want to make, I rely on this paragraph to make this submission. This paragraph tells us that the remedial action as a whole comprises different aspects, and you may not have a constitutional problem with some aspect, but have a problem with another. In fact, we know now that, and I'm jumping because I'm going to 2018 when we're dealing with a period before that. But if you look at what has happened in the Commission of Inquiry, about which we are concerned here, no sooner had it started than it approached the courts to say, oh, 180 days, no way, we can't finish in 180 days. We need 2 years. I'm making this example to point this out. You cannot say that because Deputy Chief Justice Zondo has approached the courts to vary a particular aspect of this good decision that there must be an investigation, he has a problem with the remedial action. It means there is an aspect that bothers him. And he is correct to approach the courts to say, look, I know the public protector says we must have 180 days, but I think if we must do a good job to find all thieves, not just those who took the wallet, those who are stealing the safe as well, everybody, I need 2 years. And the point I'm making to you, Judge President, my Lord and my Lady, is simply this. It is absolutely legitimate for this court, for the President, for all political leaders to be concerned about the transfer of duties from one branch of government to the other, unless it's justified. And I'm saying this, and this is my closing remark about this. We're going to have a crazy public protector one day, not now, 20 years from now. Who will think when a court has said something? I know this is a crazy example, but politics will show you crazy things have happened. We're going to have someone who will think it's a bright idea when a constitutional court has done something he doesn't, or he or she doesn't like, because he thinks judges are counter-revolutionaries, or he doesn't like what they do. People hold all sorts of opinions. You're going to have this person who says, you know what, I have political power. We're going to have the Speaker of Parliament and a couple of retired judges and politicians look at that decision of the court. It's a remedial action. It sounds crazy, but what I'm trying to illustrate, it is a legitimate concern for any political leader to look at a remedial action from a body like the Public Protector and say, I am not sure about this. Not that it's wrong. I am not sure. I'm not about to pour 200 million rand into something which may be a waste. And all I'm saying is that this court, that building block in the reasoning of the court, that it's reckless, I would like the court to reconsider that position, because another court may well think it was legitimate for anybody who is leading to have that concern. The next point is preemption. It's interesting, just JP, that in your judgment, and I'm not criticizing this point because I tried for weeks and months now to find whether preemption has ever been determined outside a judicial context. It means when you are not dealing with a judgment of a court, right? I know that what you say in your judgment, I don't think there's any reference to authority. I'm simply pointing out that, preemption belongs to those equitable doctrines like a waiver and others. And it's sometimes very difficult to know when has a party fully and unequivocally acquiesced. And I want to persuade you today that when you say, and you correct in describing what preemption is, and I don't want to quibble with the words, I don't agree with the court that we are dealing with preemption. But that disagreement is not important because it belongs to that group of doctrines. And therefore, my difference with that point is immaterial. When you say you have unequivocally acquiesced, and therefore you can't come back and say you are now reviewing, when in Parliament you told the public, you, Mr. Zuma, you told the public you have no problem with the Commission. I want to persuade you this way. You've got to look at that statement and you correct to quote it when he says, I will establish the Commission of Inquiry. But what I'm inviting you to do is to look at that statement together with other statements when he responds to Mr. Singh of the IFP, is that the idea that there is an aspect, and this is not a lawyer, this is someone who's sitting in a particular context as a leader. He says, you know, I will do this. I will do this Commission of Inquiry. I'm just not certain that I am just not certain that I will send it to another branch of government. So he has always said, I will establish the Commission of Inquiry. And by the way, I think this court was correct in its debate with my learned friend then to say, no. When he said the commission, he means the one we are all talking about. I know the argument raised there is no, it should have been it's not a, but I want to make this submission. It doesn't matter. We all know you're dealing with the Commission of Inquiry as proposed in the remedial action. The difference is this, where I slightly part ways, well, no, not slightly, where I part ways with the court, is looking at all the statements and the fact that this aspect of who must exercise this, who must appoint this, it is a legitimate concern that he exercised. For those reasons, I want to say, let's forget what the use of the term preemption, whether it's right or wrong. I understand as a doctrine why the court used it. It wanted to say he has waived his right to raise this problem. I say no. There is an aspect, as paragraph 78 in the Concord case tells us, there is an aspect of this remedial action he takes that whose constitutionality he was always never certain about. And I think we should exercise caution in saying it's not a legitimate concern. And I'm submitting that he didn't unequivocally accept that. He said, I will do this, but those conditions, I'm not happy with this aspect. And I'm saying this to say, I do not think that the doctrine of preemption became satisfied, because that condition tells us that that was not an unequivocal acceptance of the remedial action in all its aspects. So that is my point on preemption. Now, of course, those 2 points about recklessness and preemption are the building blocks. I do not want to argue the other reasons of the court, because this is an appeal. I'm not appealing the reasons. I'm saying I was dealing with them because they are building blocks to the order. And I'm saying another court may well agree with this court maybe and say, Mr. Zuma was wrong, would have lost if we think about this. But I think it's another to say to a litigant, you shouldn't have even come to a court. And what I'm persuading this court to just give us that room to say another court may well think, as I reason now, that maybe it was a legitimate concern. And I'm saying this lastly because, if you read the affidavits, and I've read heads of arguments, these debates are beginning to be the extension of the court of public opinion. It's political speech. And I'm suggesting that forget who the litigant is. My submission is that on both preemption and the conclusion that he was reckless, I would say if this court had said he was wrong, maybe you would have blown him and you wouldn't have agreed with the review. I do not criticize this court for that. I'm simply saying the prospects are high that another court will not agree that he was reckless. And for those reasons, I am submitting that there are prospects of success. Of course, Section 17(1)(a), Roman figure 2, gives us another reason. Is there any other compelling reason to grant application for leave to appeal? Suppose my first point is bad. Well, it says this, and it gives one example, and it's an apt example in our context. It says, if there is another compelling reason, including conflicting judgments on the matter. Now, I know what my learned friends are going to say is that no, conflicting judgments on the matter, it means on the costs. Well, it's important to know that because we're dealing with the building blocks that make the court conclude that he was reckless, conflicting judgments about one or two of those building blocks is important. And I've demonstrated to this court how this court itself has battled with this in two different matters and sort of dealt with it differently. And I'm saying, when you're judging a litigant who's not sitting like all of us here as a lawyer, who has other constraints, and he expresses that concern, it is not correct to assume, because we have particular suspicions of the litigant, to assume that there is an ulterior purpose when the facts are not there. I've seen in the heads of argument saying, we know Mr. Zuma's Stalingrad, I don't even know what this course means theoretically, but I suppose it means he delays and the stone walls. It's a very attractive point that everyone makes. And I'm not briefed to make a political speech on his behalf. What I want to say is that it's not a legal point, because you've got to tell us what in the facts before this court suggests that the concern he raises is illegitimate. And I'm submitting that all of these suspicions about what Mr. Zuma does and what his habits are, there are many experts on Mr. Zuma. The thing is, legally, I do not think there is a factual foundation sufficient, not just to find that he is wrong, but to say he has an ulterior purpose, it's his habit, and therefore it's illegitimate to be concerned about that. I make these two submissions to make the court think of this possibility, not just a remote possibility, that there is a court that may well deal with what I've called these building blocks that you have to reach a conclusion, reach a different one using the same blocks. And I think the chances for that in this matter are high. And lastly, it is an important matter. The example I cited may be crazy, but this matter is very important because we're dealing with constitutionalism. And it's important that our courts become this safe space rather than the extension of public opinion, so that we're able to safeguard society from the trivia of political views outside the court, because they are driven by other things. And I'm saying factually, another court may find that there is no fact to dispute the fact that he had a legitimate concern, and therefore there are prospects of success on appeal, at least on all of those briefs. But remember, we are not saying the court was wrong in how it analyzed the ground. We simply say that he should be hit with costs and say he was reckless, he shouldn't have been concerned. We think there is a court that may well think he was wrong, but will not think he was reckless. Those are our submissions.
I just want to clarify one or two things. On the first part of you saying that the approach was not that we should look at him as president, but are allegations against the president. And the public protector has set out the basis why she's crafting remedial action in a particular way. Faced with all that, he's saying it was reasonable for him to still say, I'm still concerned about separation of powers.
Should I deal with that just after? Yes, Jay, because the public protector is no higher than these courts. And therefore, I think it's perfectly legitimate for a political leader to say, I respect this remedial action and I will implement it. But I want the courts because they are the final arbiter. So I think it's legitimate if you are in doubt, and that's what the Constitutional Court tells us. It's not impermissible. The next leg of your question, JP, is should we deal with him as any litigant? Of course, I'm not suggesting that a president, a minister, a CEO, and an ordinary person in the street have the same duties and responsibilities in what they do. There is a level of understanding and duty and accountability you expect from someone who occupies that position, as the court says about the president, that he is that embodiment of our constitution. I don't quibble with that. I think he sits as president. In fact, even as a private citizen who's been president, he sits in a higher position where he must exercise better judgment. But what I'm saying is this: even when you sit there, you should never think, I'm CEO, I'm president, and the courts. You can't second guess the courts. And I think when you have something niggling you, you're not certain about, it would be irresponsible to do it the other way around. And so I'm suggesting that, indeed, you should distinguish him from any other litigant. But precisely because of that duty we expect from him, even if I dislike him or you dislike him, it's important for him to be sure that this aspect is not going to follow me and I'm going to be called. What was Zuma doing? Why didn't he check with our courts? And I think those thoughts in the minds of someone who's dealing with a multitude of attacks and ideas and being told you are wrong when you do, it's just from a court where he was told, if you are not happy with the public protector, go to the court on the Nkandla matter. Don't just ignore the courts. And he does that. He says, yes, I'm not sure about this, but I've been told before, the courts are the final arbiter. Let me go to the court. And he does, and he's called reckless. And I think it's that element that I am appealing with the court to look at differently.
Having ordered Mr. Zuma to pay the costs, and he was not a party in the proceedings. Has that point been now shelved and or abandoned?
Well, that's not a good point. It's my point, but it's a point that has been fixed. We are here now. And yes, the issue was raised. I may well say that when you have a point raised to you and you are head of state and it affects you personally, it's quite different when you deal with it at that level as at the time when you're dealing with it as an affected person in that capacity. But I don't think it's a point that goes. I think my first point and my second point on preemption are the biggest point that I think the court must take into account. I am ready to accept that, yes, I argue that point, but it's not the best point I could have to this court.
Yes. You have to address the question of test of an appeal of cost.
Yes.
There was ample authority going back decades that the court will not really interfere with that discretion. The appeal court will not interfere with discretion. I I've heard nothing. I mean, there's Merber versus Merber. I never quote all the cases, but they just as a starting point.
Yes, can I
You
go?
said the process, the meaning of exercise of discretion on a particular basis, and that is a reasonable basis. And the Court of Appeal comes to a different conclusion, that they would have decided the matter differently. They won't allow the appeal. That's the standard case. Why does that standard test, followed by, in our law, not apply in this instance?
Well, here's my answer to that. I know the rule into the law. It says the will not readily, and I don't keep it, will not readily get, because it assumes whenever you're dealing with an ordinary cost order, right? You're dealing with an ordinary cost order. Yes, the court will. You can't question how the court exercised its discretion simply on an ordinary cost order. And I think the words that deal with that are will not readily, it means will not easily. What I've been arguing to you, and I accept all of those principles, and they've been raised in some kinds of arguments. What I've been doing in the past 45 minutes, maybe I didn't mention this point specifically, is that this is no ordinary cost order. It's not. It's not an ordinary cost order. The basis upon which you make it are important enough, and they don't make it ordinary.
I fail to understand the distinction between ordinary cost orders and this cost order.
No,
And I think that we've got, as a matter of principle, why should there be a differentiation? Is the test not applicable for some reason, all the long-standing tests?
I've said this. When you have it says it will not readily do it. The use of that
Sorry,
rule.
I use the word readily.
No, you will
I
go.
don't say that.
Let's go to the rules. You may find it. Because it does talk about ordinary cost.
Yes, it is. But actually,
Right.
it has repeatedly said that
Let me find it.
not readily interfere with the discretion of the court.
Absolutely. And I think you must, that word is not there for no reason. And the words ordinary are not there for no reason. And what I've been trying to say, I thought it was obvious, is that basically we're dealing with a cost order whose foundation, whose building blocks are huge comments about a person's integrity. And so it's made punitive cost order. You must pay, you are acting as president. You will pay in your personal capacity because you've acted so badly and so recklessly. And I'm saying this is absolutely in all of those situations. I'm saying the points I have made about what building blocks you use to reach this conclusion are assumptions about him that I'm saying the court, another court may reason differently, and I think the cost order this court made is not an ordinary cost order in cases where someone is acting as head of state or in an official capacity. There could be a cost order against the presidency. There has been. And I'm not quibbling with that, and I think that would be ordinary. But I think this is punitive, and I would submit that even in the context of the old cases, I think the court must not, this is one of those exceptional cases where the building blocks to your conclusion are extraordinary, and another court may find that it's distinguishable. And when it says it will not readily do so, this may be one of those cases where the cost order that was imposed is harsher than it should have been. Those are my submissions.
I thought Mr. Masul was talking to you.
Yes, sir.
Thank you very much, Mr. Katana.
Thank you, JP.
You said nothing about cost, so you...
I'm not arguing the cost should follow the appeal. There should be a cost in that case.
As the court pleases, JP. Before we get lost what this issue is all about. Let's redirect our minds to what the application for leave to appeal is about. The President is then wants leave to be granted to him only on the basis of paragraphs 22 to 4 of his grounds of appeal. He says this in paragraph 6.2 to 7, pages 11 to 12 of his founding application. And you also see that in pages 117 to 118. I'm trying to get to. It's 117 of our bundle and 118 is where the President or the applicant filed his notice of appeal to be granted leave to appeal by this court. And as I say, he then abandons that in paragraphs 11, 6.27 on pages 11 to 12. So that these proceedings essentially are proceedings which in the applicant's own awareness aimed at appealing, and this is on page 11 to 12, paragraph 6.2. The appeal is only insofar as this court ordered, that's page 11, that I pay the costs of the review proceedings in my personal capacity, although I had instituted the review in my capacity as President of the Republic of South Africa. Then 6.3 deals with condonation. I'll come to that.
Sorry, I've lost you. I do apologize. I'm not at all with you. What pages are you referring to and on which application?
This application,
Page 11.
the current application on page 11,
Thank you.
where the applicant states the purpose of this application. In 6.3 characterizes it as that kind of an appeal. And then in 7, he goes on to state that since he's no longer the President of the Republic, I do not and cannot pursue the other grounds of appeal which do not affect him personally. I am advised that I am not standing to do so, and I also do not wish to pursue an appeal on the issues that relate to the office of the President, etc., etc. So, by that, the appellant or the applicant clearly disavows his intention or disavows himself on his own ability that he will appeal on anything other than against the cost order against him, and especially in the sense that it was a personal cost order. So that's what will take us to. I'll revert to this aspect. When I refer to the Kumalo versus Twin City developers case, when I order as to why it is opposite and competent to this court on the authority of the judgment to deny the applicant leave to appeal on the basis that when he disavowed himself of appealing on all the other issues, in other words, if he is not appealing on the merits, then on the Kumalo authority, it is impermissible for him to appeal on the cost. I'll develop that argument when I come to this. So, my Lord, but let me first deal with the arguments on condonation so that we can get them out of the way. My learned friend argued at length on condonation, and in the process, on his feet, made mention of facts that in the reading of the papers, any papers, I had not come across at all. Because in this application, a case for condonation is made only on pages 30 to 32, paragraphs 57 to 64. If you go there, you will see that that is the full account that the president makes in seeking condonation. No more, no less. So anything that was referred to by my learned friend would be impermissible testimony from the bar, because we not voted in facts that are in the papers. The real nub, it seems to me, of the president's prayer for condonation is in paragraph 62 on page 31, where he says he sought legal advice and instituted his proceedings soon after the appeal was abandoned. And then he makes the remarkable affirmation. I submit that this publication was included reasonably 36 court days after the withdrawal and 13 days since the receipt of the notification. Now, he even counts 36 court days. Now, this also must be taken alongside the page that I handed up to the court before we broke for break, in which I drew the court's attention to LPN 4, page 211. Or LP or 2 or 2 is LPN 5. The email is LPN 5. It is an email dated the 17th of April. Which speaks to what the commitment by the attorney that he now has, who was referred to by my learned friend in his address. Mancha attorneys write and say the applicant is going to bring this application, please make sure that you understand that he will be in a position to file relevant application or publications by 15 May. Now we all know that he only filed it in June. So when we talk about recklessness, but just for me to round off this point on combination, what you get out of those pages amounts to 4 things. The president, without telling us the details, and this court ought to be taken into the president's confidence for it to appreciate as to whether A, it can grant, as it has done, the intervention application, or whether the court now, subject to what we submit to it, can grant the leave to appeal. It cannot simply be brushed off by the appellant or the applicant saying, I will not go into details, but there you are. What did I have? There were tensions that I had to contend with. I had to change and attain. There were costs and all the things that he mentions. And that is why we address this and we attack it, this lackadaisical attention to detail about why the delay. We address it in paragraphs 22 to 27 of our Heads of Argument. May I take you there? Because it is important that we do not misperceive what it is that the president is being attacked. And I'll come to why we find that there was nothing wrong in the court mischaracterizing his conduct as having been reckless. But we'll take you to that. My Lord, we say, my lords and my lady, we mentioned that in his replying affidavit to CASA, the president made this statement. He says, before April 2018, I was consumed with the political events leading up to and after my resignation on the 14th of February 2018. I must emphasize that having office is not a simple matter. Important government business needed to be attended to as a matter of extreme urgency. It must be remembered also that this was a time when there were tensions politically. I, together with President Ramaphosa, had to ensure a smooth transition that was the public interest. Now, that's all detail that he gives on the basis of which he asks for combination. And that's why we say this scant justification for his delay cannot suffice. And his failure to take the court into his confidence is regrettable for two reasons. The first reason is that these reasons he gives are strikingly alarmist. There is only the faintest suggestion that Mr. Zuma was consumed by political activities to ensure the smooth and lawful transition of power after resigning from office. And we argue that the public interest can only be served where there is an honest disclosure with the court regarding what challenges he faced and which served to justify his delay. In the absence of such, his comments simply fall to be disregarded as self-serving, hyperbole. So, as I say, in the remainder of those paragraphs, and with reference to the reasons why we say so, we respond to Mr. Zuma's application, evidence on condonation, and we make the point that he is an ordinary citizen and is subject to the ordinary rules of litigation. And we argue that he has not met the burden that is placed on him to discharge that burden or to rid himself of that burden, so that this court can have a proper assessment in considering whether the condonation application is made. We say, in any event, when he replies to the EFF, perhaps jettisoning now the stance makes a more robust legal argument that he was never joined in these proceedings, and I think that what led to the debates that were engaged with my learned friend. So the peremption argument, I just want to refer this court because I intend to go to the stage where I am going to have to justify on jurisprudence why it is opposite for a person, in spite of being an executive or acting in a fiduciary capacity, why it has been the law that in spite of that title, the courts have a legitimate basis, a legal basis, actually, to mount that litigant with courts. There seems to be a cloud here. Well, he was a president now, he was a person now. There are, and jurisprudence has been developed, even post-apartheid in the constitutional democracy, that justifies the court in the judicious exercise of their discretion to mount persons with costs. And I'll take the court to the jurisprudence that has since been developed, very recent jurisprudence, where the court say it is unfair that the taxpayer should pay or should be settled with costs in circumstances where, when a person purported to act as an executive in his or her official capacity, when you strip the conduct, you begin to discover that that is the rules. When he actually was claiming he's acting in an official capacity as an executive, the truth is he was pursuing his or her own personal interest. And that is the jurisdictional basis why the courts then say, when we are satisfied that even as he purported to execute his or her duties as an executive, when you unpack, to use a political term, when you unpack this, you begin to realize that no, this was in pursuit of personal interests. And that then founds the basis for the court saying you may have acted in your fiduciary capacity. It's like a trustee. When you are a trustee in a trust, you can always say, well, I am operating as a trust. Or when you are a chief executive officer of a company or a listed company, or when you are a chairman and chairwoman of a company, you can take the position that I've done everything in my representative capacity. But when the shareholders take cudgels against you, and they take you to court, and you plead that you were acting in your representative capacity, the court is entitled to inquire into the facts that inform that decision of yours to have acted recklessly. And you can't then say, no, I was acting in my capacity as chairman, I'm insulated from any kind of crossover, let alone a political. It is how you conduct yourself. And the court would be entitled, like it has, courts here, and the court to the authority, would be entitled to say, we understand you were merely a chief executive officer of Standard Bank, and you didn't really. We understand that the shareholders are mad at you for having taken this, but it clearly on the evidence was something that you did in pursuit of your own personal interests. And the mere fact that you hold the position, like President Zuma then did, is no basis for him to say there shouldn't have been a punitive court order against my person. And I'll take it. But just to deal with the preemption point, please, Honorable, allow me just to refer to what the third respondent says in their answer in the affidavit in the main proceedings. And I have to, and this is on. Oh, Mulat, how much time do you have?
I'm asking you if you're watching the time.
No, I have not been watching the film. It's thrilled. How much?
That is correct.
5. Oh. Why did Mrs. Carter have all the time in the world? But may I just make very...
On preemption.
On preemption, can I merely refer your lordships to what the PFF said? Relevant perhaps. He says we have taken a decision to establish the Judicial Commission of Inquiry. And the emails require that. So in a sense, those are covered in the inquiry that is going to be made.
What paragraph on page are you reading?
Well, this was in the main application. It was paragraph 28 of the main application. Yes. May I just refer the court to that? May I then? I've been troubled by the remarks about the court's finding that
I would like to hear Is it unreasonable for a head of state not to be concerned about the constitutionality of such remedial action? And when he takes the matter to court, why is he said to be reckless? I'd like to hear your opinion.
Indeed. First of all, this is the first submission again. If that is what my learned friend says, it's a mischaracterization of why this court made its finding about recklessness. And the court look, yeah. But it is not true that the court said Mr. Zuma is reckless simply because he comes to court. Your Lordship will recall that in an area application, and this is common cause, in which the President had taken the public protector to this court on an interdict application seeking to interdict the publication of the public protector's report. I was present in that application. That application was simply abandoned without any explanation, in the middle of it all. And this court has made the finding on that basis, where he abandoned an urgent interdict and failed to comply with the public orders, public protector's remedial action. Now, that's recklessness, and we will not refrain from calling it by what it is, simply because there is going to be a plea where the President is going to play the victim. He suddenly is now the victim. It's a misconstruction of what this court's finding was on recklessness. Now, we know from what we read that he subsequently told Parliament that he would appoint a commission of inquiry, which eventually did. And that is clearly manifested in the paragraphs in the court's judgment, page 110, paginated page 110 of these papers, in paragraphs 187. Again, the court there eloquently expresses itself. And the conclusion is that he is not, the court's order against him is not simply because he had raised an opposition in the context of his conduct. The court says there, paragraph 187, 1, 2, 3, 4, 5, 6, 7 lines, 8 lines. The personal conflict of the President presents an insurmountable obstacle for the President and leaves credence to the conception of the remedial action by the public protector. Additionally, the statement by the President to the media and in Parliament expressing an unequivocal intention to establish a commission of inquiry and thereby preempting any justifiable basis to challenge the remedial action points to the reckless misconception underpinning the President's application seeking to review and certify the remedial action. That's the essence of the court's finding as to why it concluded that he was reckless. Not because he came to court, not because he wanted this court to explain to him what the Constitution is. I would have thought, having been the President for that long, he knew what the Constitution commanded him to do. And in view of what has been said in the so-called EFF case, when this proceedings took place, the EFF case had been handed down, and the EFF case had been very eloquent as to what the duties of the president are. So, the court goes so far as to say, in paragraph 189 of the judgment, taking all the circumstances sketched and the considerations made, we are of the view that the president was ill-advised and reckless in launching the challenge against the remedial action of the public protector. He is aware that since the allegations of state capture initially surfaced, and more so after the public protector's report, the matter remains in the public domain and requires decisive action and resolution. His court challenge has resulted in further delaying the resolution of the state capture allegation. And you will have seen in our heads of argument for this matter that we actually refer, and we have a footnote 7, where we refer to the conduct, to the very conduct which, in fact, I'll just take your lordship to because we have been accused in argument that we are in the habit of simply maligning the president in circumstances where he in paragraph 6 of our heads, we make this remark. In fact, we start in paragraph 5 and say, when regard is had to the fact that Mr. Zuma comes to this court and affirms on affidavit that there was a need for the commission of inquiry, and that, subject to his constitutional consent, subsequently dismissed, he complied with the public protector's remedial action. It is that position that he took stands now at odds with, and we say so, and we make bold to say so, because we say it's a matter of public record. If there's going to be an opposition to that, we hear it in reply. We said, this does not square with the recent widely publicized utterances by the president to the effect that there is no such thing as a state capture. And we give the reference there. Now, so when we contextualize why we believe and we make the point that the personal cost order is appropriate, it is at looking at all those things that the court found about the conduct which amounted to recklessness. And therefore, we make the point that, and I would like to make this final point, that when there is no appeal against the merits, and it is an appeal against the cause only, then the court on Kumalo's authority, there are two Kumalos in the US, but the SCA said it's impermissible. It was the majority judgment, Chief J.A., speaking for the majority, writing for the majority. It's impermissible in circumstances where there has been no application or leave to appeal against the merits or the facts or the findings. And this is what this court did. This court, in this matter, it went at length in analyzing the evidence that was before it. And there's no appeal against the merits. The majority in Bloemfontein have said, where you are not taking cudgels against the merits, then it's impossible to bring an application against cost only. And it is on the basis of that authority. And on the basis of the authorities that we cite from paragraphs 43 of our heads, and what we say there, that we say, what or not only was this court jurisprudentially enabled to mount this reckless litigant with the course that he did. In fact, a similar court sitting as a full bench in Cape Town in the matter of Democratic Alliance versus SABC and others, a full bench of the Western Cape held office bearers of the SABC to be personally liable for costs given their unreasonable and impermissible behavior in their running of the SABC and their conduct in the subsequent litigation brought by the Democratic Alliance. This is exactly what we're finding here. This application, I know my learned friend talked about, he doesn't understand this brick by brick, Stalingrad, what have you. I wrote that in our heads of argument. And I was just merely showing my knowledge of a little bit of history. What it all means is that it amounts to an abuse of court. You don't just bring matters to court and say, okay, if that one fails, I'll go back and try and find the basis. We have in our heads, which I can't refer to within the time that's allocated to me, we have developed how this argument clearly shows how the courts have followed a pattern where they are beginning to say the time has come to load the burden of the taxpayer, where people who will be claiming they were acting in their fiduciary duties do so recklessly, in abandon, because they know it is not going to hit them in their own pocket. The time has come to hit them where it hurts the most. And that is not political speak, that's courts saying so. Not once, not in one judgment, in very many judgments we have referred to in our eyes of argument. Well, those would be our submissions. Well, juniors also have been kind enough to put together a fund of authorities. May I hand the fund of authorities? And I'm reminded that the point that I took passionately about item 7, by Kumalo, there are two Kumalo judgments. It's one by the CC, Constitutional Court, the other one by the SCA. It's the SCA judgment that we are relying upon for the submission that we made.
Thank you, Advocate Zavezo. Could I request the junior, since he's so industrious and vigorous, to put my authorities on a memory stick?
He is even more adept at that than I am.
Thank you very much.
As a court.
Thank you, my lord. And my lady. I'll try again, once again, to kill two birds with one stone. When I'm talking about the condemnation application, When I deal with the question of prospects of success, I will then be dealing with the merits, as it were, of the appeal. So I'll do them concurrently to save time. Well, let's start very briefly with the condemnation application. My lord and my lady, the test for condemnation is very clear. It has now been subsumed in what we call the interest of justice. But the interest of justice must be seen also in the context of the components of a condemnation application. Much has been said, and I won't repeat what has been said about the failure to explain the delay, which is the ticket to the game, as it were. Because if you cannot explain the delay, then we don't even have to go into all these issues of prejudice and so on. Now, here, the best explanation we have for the delay is that, and that delay is even itself truncated, because the real delay is when the EFF gave notice of that it would seek personal costs. But let's be generous and say we're starting, let's say, from around about December, or even February for that matter. The only explanation we have from February is that the president had lost his job and he was moving house and so on. There's no explanation whatsoever for the period between February and April, and between April and June. Those two periods are two distinct periods, again punctuated by the fact that we were here on the 18th of April, which I spoke about this morning. Zilch, no explanation for the delay, or at least no credible explanation that the court can accept. But be that as it may, then my learned friend, Mr. Skakane, actually stands up here and says, well, there's no prejudice. How can that be, my lord? When there are parties that have been sitting here without costs, without being reimbursed of their costs for over almost a year now, because of all these ups and downs of this matter. Now it's alive, now it's gone, now it's back, now you see it, now you don't. For that reason, all the parties have been clearly prejudiced by the mere fact that their costs have not been paid. So for somebody to stand up here and say there's no prejudice to anybody, no, let's all go to the SCA and so on and keep this matter alive forever. That is the height of unreasonableness. So they fail on the first ground of no explanation of delay. They fail on the second ground of prejudice, clear, patent prejudice. But more importantly, in substance, which is where I now go to what I'll call the merits, they fail on the most important ground, namely that this application for leave to appeal has no prospects of success. And that's why we must go back to first principles. You know, we can talk here all day, but the law is very clear. Section 17 of the Superior Courts Act says leave to appeal may only be given where the judge or judges concerned are of the opinion that A, the appeal would have a reasonable prospect of success, or there's other compelling reason and so on. So, if there's no reasonable prospect of success, that has two implications. One, it would deny them the condonation leg, but it would also go to the merits. That's what I meant by this intersection between those two. Now, let's just pause 1 second, my lord. I have the dubious distinction of having ordered or argued this point here in the previous, when we were here for the review application. And I had also argued this point in the previous application, which was the President of the Republic of South Africa, the Office of the Public Protector and others. That is the interdict application where the EFF, UDM, COPE, and others were intervening parties. Ironically, the JP, because the JP is the common factor, the other common factor apart from me in those two applications. The JP was chairing a different full bench constituted of the JP, the DJP, Mujapelo, and Foray J. I would like to hand up a copy of that judgment, just for reference. And the reasons for that will become clear. It's all very well for Mr. Skakane to say we must not refer to Mr. Zuma's tendencies of being litigious and Stalingrad and so on. But the truth of the matter is that this court knows that this matter, the matter of the review, was actually an offshoot of this matter. Without wasting the court's time, what actually happened is that there was the so-called interdict that Mr. Nsabeza referred to, which we opposed. And in opposing that interdict, we made the argument that President Zuma should pay the cost personally. Why? Because that intervention was just a trick to try and get the public protector's report not to be released before the retirement of Ms. Tulimatanse. That court, we argued then, as we do now, as we did in October last year, my lord, along the following lines, and that's why these cases are twins and they must be seen together. We argued that it cannot be said that when Mr. Zuma was acting as he did, as was found, he had acted by the public protector. Remember now we're in a different zone. At that time, there was this whole debate, are these observations valid or not valid, and so on. This court has now found decisively that the so-called observations actually constitute prima facie evidence of malfeasance. So that's a fact now. It's not being appealed against. It's an established fact. And we said, we made the following examples in both cases. Mr. Zuma cannot say that when he was acting, let's call it prima facie, corruptly, that he was doing so as the head of state. You can't do that. When he was phoning Mr. Temba Maseko and saying, and so on, he was doing that as himself, as Mr. Zuma. He can't say he was doing that in discharge of his office as the president of the country. When he offered Mr. Mtabisi Jonas a position in the cabinet, or when he had Mr. Van Rooyen coming for...
Also, I think we know what...
all the findings in the public protector's report, my lord. The point I'm simply making is that the basis of this judgment, your earlier judgment, Judge President, was exactly that point. And this litigation now is simply a child of that litigation. And this is what the Judge President said in that case. I'm looking at paragraph 54. I'll start in the middle. That he was protecting his individual rights comes out more in his answer to Ms. Mentor's application. He states therein that he was protecting his personal interests. Nowhere in his papers does he state that in what respects the office of the presidency would be detrimentally affected by the release of the report and so on. And then if you can just jump the next sentence. The JP then says, that conclusion cannot simply follow as contended by the president. It is the nature of the conduct investigated that determines the issue of his personnel, whether the issue is personal or official. The president's argument boils down to this. Any conduct of a member of the executive will qualify as official as long as it is investigated under the Ethics Act. this is a misnomer. Members of the executive have private dealings in their personal capacities, and these are quite distinct from their conduct whilst pursuing the interests, objectives, and responsibilities of the departments they lead. Put differently, if that conduct falls outside the confines of the Constitution, more particularly Chapter 5 thereof, we fail to see how such conduct can be regarded as conduct of the head of state acting in his official capacity. And then the court said, therefore, it holds him liable for personal costs. Now, interesting point number one, that judgment was not appealed against. So in that instance, the President Zuma accepted that he has to pay a cost personally. He has never quibbled with this reasoning of Mlambo JP in this matter. It is therefore unreasonable in the legal sense of the word for him, for a cost order based basically on the same argument, and I say that with respect because I made both arguments, but based on the same argument that he has not taken issue with and has therefore accepted. But more importantly, my Lord, is that in the current case, we said that the recklessness emanates from this. The recklessness emanates from the fact that here you are the head of state. There are allegations involving billions and billions and billions of rands of taxpayers' money that are disappearing. And Mr. Skakanis tells us that the president, the former president, thought, well, we can't spend 200 million on a commission to investigate this. I mean, what is that? So you can't spend money on a commission to find out whether billions and billions of rands have disappeared. That is the height of recklessness and unreasonableness. Unreasonableness, as I say, in the legal sense of the word. That a reasonable president, let me put it that way, would not behave that way. Because that's the test. The test is, would a reasonable person in his position have acted in that way? And this court at least answers that question in many ways. One, this court answers that question by reference to the demands of Section 237 of the Constitution, that there must be, in matters of this nature, there should be no delay. So the actions of Mr. Zuma in playing these games of coming in and out of court and then the case collapsing in court and so on, is that it delayed the appointment of this commission. The reason why that commission is still sitting now as we speak is exactly because of that. According to the original plans of Ms. Madonsela, this commission was supposed to have started in November 2016. It would be all over now. We would know today whether or not who took the billions, with whom, how, and so on and so on. So this is not a theoretical issue, my lords. We have now sitting here a commission, State Capture Commission, which is only started its work recently, simply because of what we are debating here. So that is also the unreasonable actions of an unreasonable president. So the next point I want to make, my lords, is that the prospects of success of this application, of the appeal as such, are nil, zero. Why? Because, and I want to say this very, very clearly, you can't have it both ways. So my learned friends can't come to the court and say, okay, we abandon, or rather, we accept the abandonment by President Ramaphosa of the merits of the case. And therefore, we are left now with the naked ground on costs. The implications of that are very far-reaching, because the acceptance of the abandonment of the appeal on the merits means this. It means that the appeal court, the SCA, let's say, is now going to have to act on the basis that the findings of Mlambo JP in this matter are established facts. There's no quibble about them. So whenever Mlambo JP in this case says you should have done this, you parented, you acquiesced, and so on, that must be taken as an established fact in the so-called appeal. How on earth, if those factors are taken as facts, is that court going to say, nevertheless, accepting all the criticisms that the court has leveled against Mr. Zuma, but we still find that he acted reasonably? It's not possible. It's not possible that the same person can be found by a court of law who have stood in Parliament and said, I will institute the commission, and then with the same mouth say the institution of the commission is reviewable. And the court has, I don't have to bore the court with its own words, the court has shown how that incongruency is illogical, unreasonable, and reckless. And if it's going to be taken like that to the next court as an established fact which is unchallenged, what prospects can anybody say that the next court is going to... So they are actually in a worse off position than they were in the review application. Because in the review application, there was still room to say, no, these are only observations and they are not established. That room is gone now because that matter has been determined finally and forever. Amen. It's a fixed obstacle, a hurdle over which they cannot jump. So the appeal is limping in the sense, the alleged appeal that they are talking is limping in the sense that irreparably, the limp is irreparable because it goes there, as I say, only in its naked form as a cost order without it being related to anything, without any challenge to the underlying facts. Now, and those findings, just in the President's breach of his Section 195 duties, for example, which is another thing that this court found. You know, the Section 195 is the one that gives the duties of organs of state. His breach of the Code of Ethics, the Parliamentary Code of Ethics, that must now be taken as an established fact, which cannot be challenged. It's no longer a matter that's up for grabs. Yes. The conflict of interest, very importantly. The conflict of interest, which is again a pivot or the fulcrum of this court's finding, which goes simply something like this. You are the person who has to be investigated. The court even makes an example. Judges recuse themselves not simply because of the fact that they will be biased, but to dispel any apprehension of bias. Now here you are President Zuma, you are the subject matter of the state capture allegations. Your son, and you can't tell us that your son is your son, personally. He's not the son of the office of the president. So your son is involved with the Guptas. Those are the findings of Tulimadan. Those people, together with your son, are involved in appointing ministers and so on. We all know the allegations as JP has pointed out. And now we must certainly believe that you are the person who must appoint the person who's going to investigate whether your son was appointing ministers of state. What is that? So there's no reasonable person who can think that that's fine, that's okay. No reasonable person. Or, put differently, no reasonable person would think that if a public protector takes precautions to circumvent that perception of bias, that's appropriate. Because anything, this was in protection of President Zuma. Because if he was the person who would appoint the judge who must sit as a in the Commission of Inquiry, and that judge then finds that there was no state capture, then we will never know. Everyone will say, oh, well, what did you expect? Because the very person who was at the center of state capture is the one who appointed the judge. So if he had any interest in the country, in the fortunes of the country, in the right of the people of this country to know what happened to their money, then he would have done what he did in December. And that is why, my Lord, if you want any proof of recklessness, you don't have to go anywhere than to go to Mr. Zuma's own words. In the document, the press cutting of yes, it's page 129. If you want to know what is reasonable and what is unreasonable about Mr. Zuma's conduct, ask Mr. Zuma. Because he says now in December of 2017, just listen to this, it's incredible. This is Mr. Zuma now speaking. Statement of President Jacob Zuma and so on and so on. While I have indeed appealed the cost order as well as the order regarding the obligations of the President to appoint commissions of inquiry in terms of Section 84 of the Constitution, on the advice that there are indeed prospects of success of appeal, I am equally mindful that this matter has occupied the public mind for some time now. I have only appealed the orders to the extent that they set a particular precedent and are indeed deserving of legal certainty. Only to that extent. And then he says further, I'm not unaware that the court's order should be observed and so on. However, very important, the allegations that the state has been wrestled out of the hands of its real owners, the people of South Africa, is of paramount importance to me, and I hope to every citizen, and are therefore more deserving of finality and certainty than any novel or academic legal constitutional question. He says the importance of the state capture probe is more important than the resolution of any legal question. So he knew what is the right thing to do, and this is what he should have done. And he says, it is of such serious public concern that any further delay will make the public doubt the government's determination to dismantle all forms of corruption and entrench the public perception that the state has been captured by private interests for nefarious self-enrichment purposes. It should not matter who may have facilitated such form of corruption, no matter how powerful. The Commission must seek to uncover not just the conduct of some, but all those who may have rendered the state or parts thereof vulnerable to control by forces other than the public, and so on and so on. And then he says finally, the citizens, at page 131, the citizens deserve to know the full extent of the much talked about state capture of the state. It would serve no purpose to curtail its reach so that it affects some and not all of the culprits of this crime against the poor. So, if he knows that there's a crime against the poor, that the importance, the delay of getting to the bottom of that crime against the poor is so important, that is more important than any other legalese or legal question. Then exactly how he behaved here was reasonable. That's exactly, in fact, in other words, if we don't know what reasonableness is, this is it. Therefore, by knowing that this is reasonableness, then we also know what is unreasonableness. Unreasonableness is the way President Zuma behaved before this date, whatever the date was in December 2017. So it's a clear contrast, my Lord, with the case that I've referred to, which I say was the origin of this matter. If you contrast this case and that case, and then if you contrast his behavior here and previous to this, then you know exactly that it was reckless. And for that reason, the prospects of success are non-existent, because no court, and if I may round off with the point that Justice Barakov has made, that the court must say, the next court will have to say that this court, faced with these irrefutable facts now that cannot be challenged, having exercised its discretion on the basis of those irrefutable facts, was so clearly wrong that no reasonable court could have exercised its discretion in that fashion. Surely there is no court in this country, at least, that can come to such a conclusion, particularly when it is faced with a fait accompli in terms of the factual complex. There's no suggestion from my learned friends, at least, to say this court was like it was listening to another case altogether and just grabbed Mr. Zuma for personal cost. And the last point, my lord, is that in this case, lest we forget, Mr. Zuma actually tendered attorney and client costs, punitive costs, tendered them. And the reason he tendered the personal cost was exactly because, again, we had complained that his conduct was reckless and unreasonable. And he considered that his by tendering attorney and client costs, he was conceding that point. And Mr. Justice Mlambo, in that case, just for completion, was so fair that we were angry about his fairness, in the sense that he said, okay, I hear what you're saying about recklessness, but you did not raise those points in the papers. And therefore, I want you to go home, do your heads of argument, and deal with the question of cost so that the president can respond thereto. And it's only after that the learned judge president gave the cost order. In this case, it was different. There was no such second bonus. Why? Because the issues here were raised pertinently, both in the papers and in argument, and they were argued fully by the other side. And therefore, there can be no quibbling with the finding of this court. There's no chance under the sun, my lords and my lady, that any other court could find differently. So for that reason alone, the fact that there are no reasonable prospects of success on the test in section 17, then even if the court was inclined to grant condemnation, which we argue strongly it shouldn't, it should in any event dismiss the application for leave to appeal on the basis that it doesn't meet the test or that is now in section 17. Remember, the test has now been strengthened, that the test is whether another court would come. Will come to, would, I think you said, but with the same impact. So if anything, the test has been tightened and made more stringent than the previous test. And even on the previous test, this appeal is a non-starter. It's stillborn. It's dead on arrival.
I would like to hear you on what Mrs. Kakanisa.
Yes.
This case is a good example of one that should be granted, because what the court ordered here in this case is different to what this court did in the corruption of law, where you have a common denominator of conflict. Are you able to address that?
My Lord, I am. My Leonard, in line with your advice that we should try not to repeat, that section is going to be dealt with by Mr. Padlender. The section on corruption was safe to say this, my Lord. The point here is not so much that Mr. Nzabeza addressed this adequately. Nobody is saying that Mr. Zuma must be punished for exercising his Section 34 rights. Remember, Section 34 says that all of us have a right to have a dispute adjudicated by a court of law. No problem. The small matter of good faith, that's the problem. That section contemplates a bona fide dispute. In other words, all of us have a right to have our bona fide disputes adjudicated by courts of law, but not nefarious delaying tactics that are disguised as disputes to be addressed by the courts. So the test is very clear, my lord, at D5330A of Erasmus. And this is the point that Mr. Sikakane was dealing with. Because effectively we're dealing here with cos de bonis properties. So it says here, it is unusual to order an unsuccessful litigant in a fiduciary capacity to pay costs out of his own pocket. This is the situation we're in here. The general rule is that a person suing or defending in a representative capacity may be ordered to pay costs de bonis properties if there is a want of bona fides, right, on his part, or if he acted negligently or unreasonably. No order will be made where the representative has acted bona fide. A mere error of judgment does not warrant an order of cost de bonis properties. So Mr. Sikakane is right. That's the last point that is made there. A mere error of judgment does not warrant an order of cost de bonis. But what does warrant a cost order of de bonis is malafides, negligence, and unreasonableness. And this court said, I think it's paragraph 190, that Mr. Zuma was reckless in his behavior and unreasonable. So for Mr. Sikakane to overcome the judgment of this court, let's assume for argument's sake he's right that the conduct was not reckless. He would still have another hurdle, which to show that the conduct was also not unreasonable. Because the unreasonableness is a standalone requirement for cost de bonis properties as it is shown here. So it doesn't matter that there might be different judgments and all that and so on. The point is, were you in bringing instituting the action in itself, were you bona fide? There is no way that Mr. Zuma, who told Parliament that the commission must go on, could at the same time say he was bona fide in opposing a simple and clear and reasonable proposal by the public protector, which was so elegant, my lord, which said, I know you are the president, I know that under 84(2)(f) of the Constitution, you are the person who should appoint, but I'm simply saying the Chief Justice must select the judge, and then you still appoint the person, so that nobody can accuse you of any... So it was the most elegant solution. Anybody would have said, especially from Mr. Zuma, who claims to have a trust in all the judges, because he says in that statement of his, I have confidence in all the judges. So basically it didn't matter which judge was going to be appointed. If he really indeed had confidence in all the judges, then he should have allowed the Chief Justice to select the judge, and he appoints the judge. Again, this is exactly what he did in December now. That's how Judge Zondo was appointed. So what was wrong with what he did now, which was reasonable, which is now working? Why did he not do that? That not doing it, failure to do that, was unreasonable.
You preferred JG23, page 129. This is the statement issued subsequent to the judgment.
Yes, this one.
When the president, Mr. Zuma, then the president, elected or chose to appoint the commission.
That's correct.
This document was not the basis from which we didn't have this document when we made our order and exercised our discretion.
Of course.
It was introduced by who? Mr. Zuma? Whose affidavit?
Yes, ironically, it's introduced by Mr. Zuma. Yes. in his affidavit.
You know, what I'm saying is a lot of stuff is, for example, this.
Yes.
What are we to make of this now? Because we didn't use this.
I understand. I understand. No, I get you,
On the
man.
other hand, this is before the court when dealing with the question of condemnation.
Yes.
And you know, it has a relevance.
No, I hear you, my lord. I understand exactly the nub of the question. The issue here, my lord, is this. Yeah, the lordship is quite correct. If one is to look at, let's say, the correctness or otherwise of the December 13 judgment, purely, then you can't even look at this. Because this, I think it was the 22nd of December or whatever. Let's say it was a week later after the Nasrec conference. So,
what's its relevance?
yes, from that point of view. But here's the relevance of this, my lord. It's relevant in two ways. Firstly, it is the fact that it has, well, it's relevant because they have put it in to try and justify their actions. But it's also relevant because it's a mirror, if you like, my lord. That's why I say if you want to look what would have been the reasonable thing to do for President Zuma, all you have to do is to look at this document. Because what he did here, which is now working somewhere in part-time, is exactly the reasonable thing. We were saying this, all of us, at least on this side of the fence, in October last year, to this court. We were saying, why does Mr. Zuma have to delay the entire country for a year for it not to know whether the state is being captured, even as we are speaking now, whether billions and billions are not being siphoned away. And then he can have his academic debates about whether
Does this render the appeal moot in some way?
Absolutely, it does. Well,
Because we can take subsequent events
into account. Particularly, no, of course, particularly when
if it's now rendered moot.
Yes. That's the third point, my lord. Particularly now when the application for leave to appeal has been filed late, and the basis for that lateness is all the subsequent events, including the 14th of February.
That's on condemnation number one.
Absolutely.
But it also could impact
On
the
merits.
merits. If the issue on the merits
Is still alive.
not alive,
Yes.
well, the issue of cost is alive.
Yes. But my lord.
That's a fundamental basis based on the Kamala case. Is that you can't having the merits now being accepted undercuts prospects.
No, your lordship raises a crucial point because remember, in terms of the SCA rules, or well, not even the SCA rules, just the Act, there are two such hurdles that Mr. Zuma has got here to jump. The first one is the one that Ms. Leroux, my learned friend Ms. Leroux, was alluding to, which is that at best this is just a pure cost order. That alone is a problem. But the second problem now is that in any event, even if it was about the merits, it's moot in the sense that that which we're all debating whether it was reasonable or not has actually now happened. And nobody has said this is unreasonable, the appointment of Judge Zondo by Justice Mokoena. So it's important for that as well, but it's also important for the purpose which I presented instead, which is, as I say, the yardstick against which the reasonableness can be tested to exist or not exist.
Thank you.
As God business, and as far as costs are concerned, my learned friend, Mr. Skakan will be glad to know that we ask for costs in the ordinary scale. It's close to Christmas. We won't ask for personal costs against them for this particular application.
Not personal costs. These are personal costs.
No. Oh well, because he's no longer. No, I'm simply saying, my lord, we're not asking for punitive costs. Punitive costs. That's correct. Yeah. Unfortunately, the cloak of the office has now since disappeared. That's correct.
My Lord, just on that point, because I didn't address it, we are asking for punitive costs.
Yes. Have you given notice to that effect?
Yes, ma'am.
Where is that notice? The normal practice is to give notice. Where is that to be found?
There is, I know that we have it in our heads of argument. Can I come back to that, my Lord? I think Mr. Butler is itching to.
I think I'll allow Mr. President to argue. I know that I said we must finish today, but I didn't consult the staff that's helping us here. So if there's a sudden walk out from the staff, don't be surprised, because I didn't consult.
Well, we will do our best to keep your staff interested. So look, we have listened carefully to the arguments advanced, and we will ensure that we do not repeat it. We propose during the course of this address, my Lord, to divide it into two parts. Firstly, we will deal with the test for an appellate court to interfere with the costs order, because it seems to us that there's some more that needs to be said on that. And secondly, we will deal with why there are no reasonable prospects of success. And in doing so, we will deal with what our learned friend sought to portray as a disjuncture between this case and the Masana judgment. And we will also deal with an additional reason which supports this court's conclusion. That was the President's, the last minute, about turn before you when the main matter was argued. And we will demonstrate that that is an additional and further basis that supports this court's conclusion. My Lord, we did email these short heads of argument to your registrar as requested. Do your lordships and lady have, or could I hand them out? Could I hand a copy out? Thank you, my Lord. My Lord, we begin at paragraph 3, page 1, with the effect of section 17.2a and the principle that courts should not be detained by costs appeals only. Your Lordship has heard arguments on that. We've heard about the Kumalo case. We endorse that proposition, but we do not propose to argue it, because it's been amply covered. But more importantly, my Lord, is what appears at page 4, paragraph 2. And that is the standard for interference by a court on appeal in relation to the costs of the court. And we make the point at 4.1, which has already been discussed, the trite point that when a lower court exercises its discretion regarding costs, it is exercising a true or broad or wide discretion, and that means that an appeal against a costs order will not succeed unless the appeal court concludes that the lower court misdirected itself in the exercise of its discretion. So while my learned friend says, well, courts do it seldom or whatever, it's much more specific than that with respect. The court has laid down again and again, our courts, and we've cited the Constitutional Court's case. There the court said the court made an order it deemed appropriate to protect its process and exercised its discretion in doing so, unless it exercised that discretion unjudicially or on a wrong principle. This court has no basis to interfere. So for our learned friends to succeed in persuading you that there are reasonable prospects, they must persuade you that there are reasonable prospects that an appellate court would conclude that this bench exercised its discretion unjudicially or on a wrong principle. Now, our learned friend Mr. Sikakani appeared to suggest that that was the approach that applied to ordinary costs orders, but that it didn't apply to special costs orders of the sort that we're dealing with here. Lord, if that was the contention, that contention is wholly without merit. And could we give your lordships and ladyship the authority? Firstly, my lord and lady, and this isn't in the head, so if the court would make a note, on the principle that a punitive costs order, attorney-client costs, is subject to the same discretion and the same limited appellate interference, could I give the court one example? It's the decision of A.B. versus Minister of Social and Development, 2017-3 of the South African Law Reports, page 570, a decision of the Constitutional Court at paragraph 326. I beg your pardon, it's A.B. versus Minister of Social Development, 2017-3, SA 570 CC, at paragraph 326. There the court was confronted with an attorney-client costs award made by the High Court, and on appeal the court said the court exercised its discretion in doing so, therefore the heightened standard applies and we're not going to interfere. So we know from that case it applies not just to party-in-parties costs, but also to attorney-client costs. We know also, my lords and my lady, that it applies to personal liability for costs, and that is demonstrated by the case we have quoted at paragraph 4.3 of the heads. That case was a different context. It was a certification of a class action. The court will see the reference on the following page. It's Mukadam. It's at footnote 4. Mukadam versus Pioneer Foods. It's the decision of the SCA. But could I just explain what the case was about? That case was a long and complicated debate about whether to certify a class action for bread distributors in that case. And the court was trying to grapple with the different options for what kind of classes you could have. And it said the only advantage that was said of one of the options was the notion that if you have a certain kind of action, you would immunize against personal liability for costs. And the court said, that does not seem to me a good reason for allowing a class action. On the contrary, the potential for personal liability for costs, so that's what it's dealing with, will often serve as a salutary restraint on frivolous actions. And then in the last sentence, indeed the court that becomes seized of the case, that's the trial court, has a wide discretion to determine where the costs should fall. So that is the SCA speaking, making absolutely clear that this notion of a wide discretion for costs applies also to a determination of personal costs awards. So we know that for ordinary costs awards, for punitive costs awards, and for personal costs awards, all of those are discretionary. All of those involve a wide or true discretion, and therefore this court's judgment is such a discretion. It can only be overturned on a showing that this court didn't exercise itself judicially or on a wrong principle. And what is absolutely striking, with great respect, Judge President, is that when you read the grounds of appeal put up by the President, and when you read the President's heads of argument, and when you listen to our learned friends arguing for the President, not once did they explain what the wrong principle was that was applied. Not once did they articulate why this court's judgment, or this court's exercise of discretion, was unjudicial. The most that you were told was that this court had erred, that there was a prospect that another court would disagree. But with great respect, my lords and my lady, that is not the test. It is not a correctness standard. It is not a question of error. It is a standard that they have to show unjudicial exercise of discretion or a wrong principle. And as we stand here today, having read their documents and heard their argument, your lordships and your lady will be entirely unaware as to what wrong principle you apply and as to how you exercised your discretion unjudicially. On that basis alone, we submit the application for leave to appeal bears no reasonable prospects of success, and it must be dismissed. Judge President, members of the court, that deals with the first half of our argument, and we submit it is dispositive of the case. Could we now turn to deal with the second argument? And the second argument is, even leaving aside that heightened test, even if the test was somehow just reasonable prospects and error, how it is that they cannot succeed. And what we will demonstrate with respect is that there is no basis for criticising this court's award or of costs personally, and in fact it was plainly correct. In doing so, we'd like to deal firstly with the arguments advanced in relation to, can I call it the Nkosana judgment or the Corruption Watch judgment? Because at the centre of our learned friend's argument was the contention that somehow there is a rupture or a disjuncture between this court's judgment in Corruption Watch and this court's judgment here. And so the argument goes, well, that just demonstrates that reasonable people can disagree, and therefore the President couldn't have behaved unreasonably. But with great respect, we submit that the Nkosana judgment demonstrates exactly the opposite. Because what it actually demonstrates is that this court's conclusion was unremarkable and plainly correct. And I need to do that by demonstrating that with reference to the judgment. Now, the passage in this court's judgment in this case, to which I wish to refer, is at paragraph 187 of this court's judgment. That is to be found at page 111 of the papers if the court is in the same bundle I am. So it's 187, paragraph 187. And that's what this court says. It said, there could have therefore been no doubt in the President's mind when initiating this application, seeking as he did to challenge the public protector's power to constrain his power through remedial action, that his own powers were not untrammeled in the face of such remedial action. The overarching basis for the remedial action challenged by the President is that he is personally implicated in the malfeasance and improper conduct investigated by the Public Protector. The personal conflict of the President presents an insurmountable obstacle for the President and leads credence to the conception of the remedial action by the Public Protector. Put more simply, the President is conflicted because he's got a personal interest. Therefore, it was obvious that the Public Protector couldn't leave it to him to pick the judge, and therefore the Public Protector adopted the remedial action she did. She took out of his hands the power to pick the judge, and she put it in the hands of the Chief Justice. That is what this court is saying. It is saying that is plainly and obviously correct. That's this judgment. Then you go and read the Corruption Watch judgment, and I'm now only speaking about the High Court judgment because, as the Judge President pointed out, the Concourt didn't get there purely because the incumbents have changed, so it wasn't necessary. But in paragraphs 112 to 115, this court in Corruption Watch dealt with the question: who was to appoint the new NDPP if the President, and I'm not sure this is, I see Justice Barofovitz looking for the judgment, I do apologize, I'm not sure you have a hard copy in front of you, but we will make it available, but perhaps I could simply read it. But this court will recall, no better than the Judge President, that what had happened in that case is that by virtue of the court's conclusions, there was going to be a vacancy in the position of the NDPP. And the question was, who was going to fill that vacancy? Ordinarily, it would be the President. And this court held, pursuant to its power to grant a just and equitable remedy, that it would take the power away from the President and give it to the Deputy President. And what it said was, at paragraph 112, in a rights-based order, it is fundamental that a conflicted person cannot act. To act despite a conflict is self-evidently to pervert the rights being exercised, as well as the rights of those affected. And section 196(2)(b, that's of the Constitution, makes that clear. If conflicted, the individual simply cannot act, is unable to act, whether section 90 was there or not. And then the court said, in our view, President Zuma would clearly be conflicted in having to appoint an NDPP, given the background to which we referred, particularly the ever-present spectre of the many criminal charges against him that have not gone away. There is no longer any obstacle in the way of the criminal charges proceeding. It seems incongruous, I've left out a few words, it seems incongruous that under those circumstances, President Zuma should then be seen to be appointing the NDPP, since his conflict, both actual and perceived, is self-evident. Judges routinely decline to sit in matters in which they are conflicted. Those two dicta with respect could have been written together. They are entirely consistent. They say, when the President is conflicted because of his personal involvement, he cannot, in this case, pick the judge to investigate him, and he cannot, in that case, pick the prosecutor to prosecute him. In this case, the court says, obviously, the just and equitable remedy for the state, for the Public Protector to adopt was to allow the Chief Justice to pick the judge. In that case, the court said, obviously, the just and equitable remedy is to allow the Deputy President to do it. With great respect, Judge President, those two cases are entirely coherent, entirely consistent, and make clear what this court made itself clear. It was obvious that a man in the position of the President, the then President, could never pick his own judge, just as he could never pick his own prosecutor. And so the central piece of our learned friend's argument, this purported distinction or disjuncture between the two judgments, must fall, because in fact what they do is they demonstrate a perfect coherence and a perfect principle. And if our learned friend implicitly accepts the correctness of the judgment in the Nkosana case, it must follow that the approach of this court was similarly correct. That is the first reason that there can be no criticism of this court's approach and no reasonable prospects of success. Allied to that, my Lord, is the contention by our learned friend. Our learned friend gave an example. He said, well, what would the position be if the Public Protector had directed that a judge be investigated? But with respect, the example demonstrates how absurd it is, because section 182(3) of the Constitution makes expressly clear that the Public Protector may never inquire into judicial functions. So the only two examples, so that could never happen. So the only two examples our learned friend comes up with, the Nkosana judgment and the judge example, sow the seeds of their destruction. Neither of them demonstrates that this President behaved reasonably. In fact, they demonstrate quite the opposite. So the first reason, therefore, if I can just summarize, the first reason, therefore, that this bears no reasonable prospect is that there's been no demonstration that the President's concerns were reasonable. No demonstration that the President's concerns were legitimate. Quite the opposite. But let me assume that I'm incorrect. Let me assume that the President's concerns were legitimate and reasonable. What then would the reasonable President have done? And this has been alluded to, so I'll be very brief on it, but I need to emphasize one point. The reasonable President, if all that he was worried about was about the precedent and the principle, he would not have sought to review and set aside the Public Protector's report and failed to appoint the Commission. He would have carried out the Public Protector's report, appointed the Commission, and brought an application for a declarator, in which he said, I've appointed the Commission. The Commission must get on its show on the road. But I do have a real legal concern about whether this is permissible, and I'm seeking a declarator in order to achieve clarity. That's what the responsible President would have done. A President who truly was concerned about legal uncertainty rather than intent on delay. But we know that that wasn't what was done. Instead, what the President does is he brings the review, and he uses the review as an excuse not to appoint the Commission. And it is no answer with respect to say, well, the President was worried about the wastage of money. With great respect, it is not a wastage of money to carry out an order by a constitutional institution directing the investigation of what was common cause on these papers was wide-scale corruption. That could never be a wastage of money. However, the academic constitutional point, which we now said troubled him, however much that troubled him. If you were truly concerned about getting to the bottom of it, you would have appointed the Commission, told it to get on with it, and brought your application for a declarator. And in that declarator say, I know that this might normally be academic, but it's a very important point, and I didn't want to stop the Commission, but I want this point resolved, and I appeal to the Court to exercise its discretion. And in that case, in that good faith attempt to resolve a legal issue of concern, no court would have stopped it. The court would have pronounced upon the issue, it would have got on with it, but as our learned friend Mr. Mpofu said, by now the Commission would be finished. But of course he doesn't do that. He does the opposite. He uses this review on this purported academic issue in order to have terrible practical consequences, which is to delay the much-needed Commission. So that is the second reason that there can be no reasonable prospects of success of an appeal against the costs order, because his behaviour was truly reckless, unreasonable, and in bad faith. But again, assume that I'm wrong. Assume that I'm wrong on the first point about the principle. Assume that I'm wrong on the second point about what a reasonable person would have done. Assume that a reasonable person, assume he had genuine concerns, and assume that he really felt he had to review this decision for whatever reason. What would the reasonable President in those shoes have done? Well, what the reasonable President in those shoes would have done is he would have at least sought an effective remedy. He would have come to court, he would have pursued the review, and he would have said, I seek to have the matter remitted to the Public Protector so that it can be properly investigated. Because he would have said, the Public Protector can't create a commission, the Public Protector can't appoint a judge, it's an excess of powers, but I want the Public Protector to investigate them because I accept that there are legitimate issues. So the reasonable President, the good faith President would have said, review and set aside and send it back to the Public Protector. And for the first 2 days of argument in this matter, that is what this court thought was being asked. Because there was never a suggestion that there should be no remittal. But this court will recall, in reply, our learned friend, then acting for the President, Mr. Semenya, was asked by the bench, are you seeking remittal? The answer came, no, I'm not seeking remittal. There was then an adjournment. There was an opportunity given for the President to give instructions. And the specific instruction given was, I do not want remittal. Now, I'm going to demonstrate in a moment why that is fatal to the President's contention of good faith. But could I first deal with a different point? This court didn't take that about turn into account, or didn't rely on it in its costs award, in its cost discretion. But that, of course, doesn't mean that it's irrelevant to these proceedings or any appeal. Because as this court will well know, an appeal lies against an order rather than the reasons. And that means that the order can be defended on any basis on the papers. So in determining whether reasonable prospects of success exists, this court will weigh both its own findings against the President and also other findings against the President an appellate court could make. And the authority for that proposition, if I could give it to the court, is the decision we've cited at footnote 5. It's the decision of South African Reserve Bank versus Khumalo, 2010, volume 5 of the South African Law Reports, page 449, a decision of the SCA at paragraph 4. That's a different Khumalo case, yet another Khumalo case. But the point that is made there, quite expressly, is that it's open to a litigant to defend the court's judgment on appeal on a different ground that appears from the papers. So if this case were somehow to get leave to appeal, and if we were somehow to go to Bloemfontein, we would be entitled to stand before the SCA and say the costs award was right on the bases articulated by the High Court. But in any event, it was right on a separate basis, and that would prevent the appeal succeeding. So could I just briefly develop that argument, and let me say that this is not a new argument, because it is the argument that was put up in our supplementary note that was filed on 27 October, I think that was the date, 2017. So this is not a new argument, it's not a surprising argument, but it is one we respectfully submit that is dispositive of the prospects of success. Because, and I'm now at page 4 of the heads of argument, Justices, the paragraphs 10 and following.
So we have to take into account new arguments in considering the project.
You can take into account new arguments that are available on the papers and that I could advance in Bloemfontein. Because if that argument is destructive of the appeal, then there's no point, with great respect, becoming immersed in a debate about whether the other reasons were good or bad. Because on Kumalo and a series of cases that followed, I'm entitled to go to Bloemfontein and say that this is dispositive. So if this court is persuaded that this in itself is a ground or a basis to say there are no reasonable prospects, this court can rely on this issue. So could I deal with that point? And that is, the point is as follows. So the point goes, the President pertinently, directly, expressly, via his legal representative, says to this court at the conclusion of the last hearing, we don't seek remittal, we just seek reviewing and setting aside. Now what does that mean, that remedy that is sought? Well, what that meant is that what the extraordinarily serious matters in the Public Protector's report, common cause that they were extraordinarily serious, they would have to be dealt with as follows. There would be no investigation of them at all by the Public Protector, because the matter wouldn't be remitted back. And there would also be no investigation of those issues at all by the Commission envisaged by the Public Protector, because her report would have been set aside. The only way that those issues could have been investigated is if the President had himself hand-picked a commission to do it. So, in other words, the effect of the President's remedy sought in these proceedings was the Public Protector can't investigate. The Commission, with a judge chosen by the Chief Justice, can't investigate. The only person who can investigate is a commission handpicked by the President. And let's be clear, that need not have even been a judge, because as we point out in the footnote, commissions don't have to be headed by judges. There's nothing in the Commissions Act that requires a judge. So the President could have picked any attorney, any advocate in the country, of his own choice, to go and investigate himself. That is the effect of the remedy that the President sought. And we submit that when you just articulate it like that, it reveals plainly what the President's motive in bringing the application was, and in seeking that remedy. He sought to ensure that the issues raised in the Public Protector's report, which implicated him, his friends and his family, were not investigated at all, unless he got to pick both the person who was doing the investigation and the terms of reference for the investigation. No investigation at all, unless he picked the investigator and the terms of reference. And that is despite the patent conflict of interest and the patent lack of perceived independence that would have been involved. And that contention, we submit, is quintessentially about bad faith. It is also totally destructive of the argument that the President relied on so heavily last time, where he said, well, the problem with the Public Protector is she didn't make factual findings. This court will record in the dim, distant reaches of last year when we argued this, that there was a long argument that the Public Protector had to make factual findings before engaging in remedial action. Well, if that argument had been advanced in good faith, what was the remedy? Refer back to the Public Protector to make the factual findings. No, says the President, I don't want it remitted to the Public Protector. So he now says, on the one hand, the Public Protector's report was flawed because she didn't make factual findings, but on the other hand, I don't want to remit to her to allow her to make the factual findings. Your Lordships and your Ladyship will be aware of the fundamental and general principle that a party is not entitled to blow hot and cold. A party is not entitled to approbate and reprobate, and we've given you the principles. It is hard to imagine a more clear example of blowing hot and cold and approbating and reprobating than saying, the Public Protector's report was invalid because she didn't make factual findings, but I don't want it sent back to her to make those factual findings. It demonstrates that the very arguments he put before this court were not just wrong, because we accept wrong is not enough. They were in bad faith and brought for an ulterior purpose. And so we submit with great respect that this is the kind of case the courts have had in mind for 100 years when they said, and I'm now quoting from the paragraph 14, the dictum which says, when the court finds that an attempt made to use for, I beg your pardon, when the court finds an attempt has been made to use for ulterior purposes machinery designed for the better administration of justice, it is the duty of the court to prevent such abuse. That is not this court. That is not the Constitutional Court. That is the AD in Hudson versus Hudson, almost 100 years ago in 1927. But it's been endorsed by the Constitutional Court last year in Lawyers for Human Rights versus the Minister of the Presidency. And that, let me say, Judge President, would apply to anyone who abuses the courts. Because there seemed to be a suggestion that the President must be treated like an ordinary litigant. Judge President, if this court, in the motion court, in the trial court, or in any court, finds that someone has brought an application in bad faith for ulterior purposes, this court is entitled to stop the matter there and then and direct that punitive costs be paid. That applies to every litigant. So that applies even if the President is regarded as an ordinary litigant. But of course he's not an ordinary litigant. He is a litigant with a heightened sense of duty because he is the bearer of an office and he is the bearer of the duties imposed by the sections we've quoted at paragraph 14. Section 83B, 83C, 96.2, 181.3, and let me add, 195, on which this court relied. So if it would be good enough to say to an ordinary litigant, Joe Soap suing his wife, that you have behaved improperly and in an ulterior fashion, and I'm therefore ordering punitive costs against you, it must follow that it's permissible to say so to the President, who bears a heightened duty to promote access to courts, to promote the office of the Public Protector, and to achieve the efficacy. And it must apply with a heightened emphasis because it's the President not litigating with his own money. Joe Soap, who sues his wife, may be a terrible person, and he may have been terrible to his wife, but at least he's wasting his own money and the court's time. If the President is found to have behaved improperly and with an ulterior purpose, he's not also wasting the court's time, but he's wasting taxpayers' money. And that plainly cannot be allowed. And that plainly is why this court's order was justified. So if you leave aside everything else, if you forget the fact that Nkosana demonstrates the correctness of this judgment, if you forget the fact that there's a heightened standard of review, if you forget the preemption point, you forget everything else, and you just focus on the remedy that the President sought, it was a remedy sought in order to prevent him. The only effect of that remedy would be no one could investigate him unless he picked the person to investigate and the terms of reference. That is quintessentially bad faith. And on that basis alone, apart from anything else, the order made in this court was not only unimpeachable, was not only judicially granted, it was correct. So even if the standard were correctness, there would be no basis to grant leave to appeal. So for all of those reasons, we submit that the application for leave to appeal should be dismissed and that the costs of two counsel should be directed to be paid by the applicant personally. He is here in his personal capacity. We have not sought punitive costs in this application, and we therefore do not seek punitive costs. We seek costs on an ordinary scale. Could I just check if there's anything else? Judge President, those are our submissions unless there are any questions.
Thank you very much.
Thank you.
Judge President, I'm conscious of the time. I'm conscious of the eloquent and articulate arguments that my learned friends from fellow respondents have made. So I will be as brief as possible and not repeat what is set out in the heads. But there are some points that I'd like to highlight that have, I think, developed in the course of the afternoon's argument. But I'd first like to begin with a foundational submission in response to what can only be described as a vitriolic attack on my client by Mr. Zuma. And it was repeated in argument by his counsel today. And as I understand this argument, it says that he's being discriminated against here. It says that his constitutional right of access to justice is being denied. He goes so far in his answering affidavit to say that CASAC is driven by hate. Of course, all of this is denied by CASAC. But more importantly, CASAC submits that to the extent that questions about access to justice are engaged in this case, access to justice is not an unfettered right. It is not an entitlement to appeal. That's why the courts have developed tests and limitations on this. It's why it's a question of obtaining leave to appeal. It's why various other principles are engaged in this case. Mootness, preemption, acquiescence, a reluctance to interfere with costs orders because they're an exercise of a true discretion by the High Court. So access to justice is only engaged in this case subject to him getting through all of those hurdles. So to take issue with his application and to oppose his intervention, his condemnation, and his leave to appeal application is not driven by hate. It's to ensure that precisely the constitutional framework that KSA seeks to advance is advanced and progressed and observed in the disposition of these applications. Similarly, when we get to the point of the importance of the issue and how that relates to prospects of success, and to Justice Borakowitz's inquiries about what he should make of the fact that the Commission has been appointed and is running, and in essence, the President observed the full terms of the order. He just says he was doing it for another reason. He was doing it because of public interest. He wasn't doing it because he believed in the constitutional point. Simply to state that the reasons why he does it are not relevant for the purposes of your inquiry into what significance those subsequent events have. He has all but observed the terms of this court's order. Therefore, muteness, preemption, acquiescence, all of those limitations and hurdles that he must overcome here have not been overcome. We deal with the leave to appeal grounds in our heads commencing at page 17, and I'm not going to rehearse all of those given where we are in the course of the argument today and the time this afternoon. But I would make 2 points. The first is that he says he had a good reason to review, so it wasn't reckless and it was reasonable. It wasn't ill-conceived and a non-starter the way the court described it. But in the oral argument today, all of these questions of his conflict of interest, perceptions of bias, the critical question of the country having confidence in the person appointed to complete the investigation started by the Public Protector's Office, the principles of recusal and how they played a role in the court's reasoning around the question of the relief here and eventually the costs order. The mootness point, the preemption point, and the way the court dealt with the Public Protector's complaint of resource constraints. None of those have been addressed by our learned friends for Mr. Zuma. So it is not merely that he had a firmly held bona fide belief that there's this important constitutional principle that must be decided by the court. He also must take account of all of those other features of the context that is relevant here. And we would say that in addition to everything that's in the heads, he has failed to do that here because he, most importantly, has not dealt with the fact that the court was concerned about the nature of the allegations then in the public domain. In the public domain from the Public Protector's report, but also from the Gupta Leaks emails, and seemingly a deluge of daily media reports indicating what the court described as potential fraud, corruption, malfeasance, maladministration, a collapse of our governance framework and the constitutional project. So it doesn't overstate it to say that ensuring that the constitutional principle of accountability must be vindicated here. The country should have confidence in the commission that would investigate these very important allegations. And all of that goes to engendering confidence in this process where, in essence, he complied with this court's order, making the issue moot. So, my lords, my lady, unless there are questions, those are our submissions, other than what's in the written argument with respect to the application for leave to appeal. To then turn to the condonation application. And again, very conscious of timing and batting order, I would merely refer the court to where we, in our heads of argument commencing at page 6, deal with each of the factors that form the interests of justice inquiry. So the length of the delay, explanation for it, prospects of success, prejudice to other parties, and the importance of issues. But what I'd like to highlight from the argument this afternoon are 3 points with respect to the condonation application. The first is this. In answer to questions from the bench and the issue raised in the answering affidavits, that there is scant detail about why the former president delayed so long, what was going on in this period from February all the way to June when he files. On the papers, all that we have is moving house, political tensions, waiting for the undertaking from the state attorney that my legal fees would be covered. Today we hear evidence from the bar that there was some miscommunication between Mr. Hulley and the new attorneys, that there was I think we even referred to some sort of fight about the costs and how fees would be dealt with, that there was some animosity or tension there. None of that is on the papers. That was evidence given from the bar, and we would submit must be disregarded. Because all that is on the papers, and I'll merely give you the reference but not go there, in the founding affidavit, page 30, paragraphs 57 and 59, all that Mr. Zuma states there is that he needed to sort out who would pay legal fees. It was difficult to obtain representation until that had been clarified, and he then instructed his attorneys to pursue the application. So all of this...
But we don't have details.
We have no details.
On dates, facts that underlie these allegations.
That is, with respect, absolutely correct, Justice Markovitz. And in fact, if we look at the state attorney's undertaking, which is, the final permission granted that sees the application launched, that's in your bundle at paginated page 132. It appears that there was a request. We don't know when that request was made, on what terms, how early that came, how close it was to February or December or April. We don't know anything about this request. So there's simply no detail as to why this delay was occasioned, and the evidence from the bar today we would submit should be disregarded. The second of the 3 points I wish to highlight on the condonation case is for us to pause and step back and recall the purpose of condonation. It's to prevent harshness, and that would result if there was a formalistic application of the rules of court in a set of circumstances. And that's why the interests of justice are the overarching focus of the inquiry. But here, if we look at the full conspectus of Mr. Zuma's conduct, his failure to explain what took so long, the unreasonable and reckless nature of the pursuit of the review in the first place, as we would submit correctly found by this court in its judgment. What in fact is going on here was that he was undermining the constitutional principle of accountability. He was not expeditiously and reasonably and fastidiously pursuing his personal interest in addressing the personal costs order that was made against him. So the final point that we would highlight on the question of condonation arises because this important principle that he wishes to vindicate, his constitutional zeal that KSAC obviously is relieved to see that he now exhibits. The citizen, the number one citizen, President Ramaphosa, the citizen who is the custodian of the Constitution, the way Mr. Zuma used to be, he applied his mind to this issue and decided that it was not an issue that needed to be determined by the court, and hence he withdrew the application for leave to appeal. So we would submit that as a private citizen, we don't understand the basis on which Mr. Zuma persists in challenging this remedial action, where the primary custodian of our Constitution has unequivocally indicated that he doesn't think that this issue warrants further attention from the court. And if we recall the issue, if we describe what it is that President Ramaphosa has decided is moot and need not be pursued, it's a personal conflict of interest, personal implication, and very serious allegations of corruption, malfeasance, and state capture. That person, as a sitting president, should be precluded from appointing the judge to run a commission of inquiry. The fact that the current president decides that that's unlikely to arise again means that we would submit that that factor should also be taken into account when one evaluates the importance of the issue to be pursued in the appeal and the prospects of success. Then finally, unless there are questions on the condemnation opposition, and again, let me reiterate that I hope I can respectfully refer you to our submissions in written argument. We seek the dismissal of both applications, the condemnation and the application for leave to appeal. And CASAC has and gave notice in the heads of argument and to my learned friends this morning, I do have an instruction to pursue punitive costs and a personal costs order. And that's because if we understand the position of the state attorney undertaking, the state attorney will still pay for costs in the courts. Therefore, CASAC seeks a personal costs order against Mr. Zuma in the event that the condemnation and the leave to appeal applications are dismissed. Of course, there's some circularity to that argument because the state attorney's undertaking says he has to refund out of his personal funds if he is unsuccessful. So there may be some inevitability to the outcome. But we would submit that if the court is with the respondents and dismisses the condemnation and leave to appeal, it should be a personal costs order, and we would submit on a punitive scale.
Have you given notice that you intend to ask for costs on a punitive scale?
It is not in the affidavit, but it's in the heads, and I did raise it with my learned friend this morning.
To ask for punitive costs, there must be informed about that, have an opportunity to respond. And I don't. The first we hear of this is from the bar. Unless you can point out to some notice given in the papers.
Justice Borachowicz, on the question of a punitive costs standard, that notice was not given.
Yeah, that's what I'm talking about.
Yes,
I'm not talking about personal.
So personal costs was
the punitive
yes.
costs.
And in the event that the court finds that that notice was essential to the application, then obviously we would just want personal costs.
What I understand is the practice, when we look at the whole range of constitutional other provisions, entitled to be apprised, the party against whom you're seeking costs is entitled to be apprised of the fact that costs on such scale are being sought, and afforded an opportunity to advance reasons why such costs would not be applied.
Justice Borachowicz, in light of that, we would then just pursue personal costs against Mr. Zuma, but not on a punitive scale. Those are our submissions.
Punitive cost, you mean personal cost, do you believe?
Sorry, again. Yes, so personal costs, but not on a punitive scale.
Ordinary costs.
Yes, ordinary costs, not on a punitive scale, but in his personal capacity, not state attorney, subject to potential refund.
Okay. Thank you very much, Mr. Ruth.
President, I'm still with you our short reply, but Mr. Leonard friend, Mr. Nzimeza, just one huge stone to throw at Mr. Zuma. After meeting him.
Judge President, it is in relation to exactly the question that Judge Barros has raised. We have raised the question of what we call personal costs in paragraphs 40 and 41, pages 351 to 352 of the present proceedings. And that is also in reference to the remarkable position of the state attorney during my brief to fund the litigation of this case, in spite of the fact that so we have raised it on paper. In fact, the reference to personal costs is clearly intended to be a request, a prayer for a punitive cost order.
Page 351.
Page 351, paragraph 40. In fact, we start this debate on costs from page 350, where we develop this diagram from paragraphs 37, 38, 39, quite clearly intended to be a punitive cost order. We also make the same prayer for that kind of cost in paragraph 50 and 59 of our head of public.
But it's not on a punitive basis. It's on the basis that he personally pays those costs and not to be paid through organs of the state, but not on a punitive scale. The way I see the argument that comes through in respect of costs from paragraphs 37 to paragraphs 41.
Well, I suppose, the dilemma that the EFF had was, we are in a position where we have to determine whether we should serve the taxpayer with costs now that we have established that the state aid is going to foot the bill, or whether, because that's what paragraph 38 on page 350 or paragraph 40 indicates.
Are you trying to?
Yes, but you can't come and link those two together. You can't. You know that you can't do that. On the personal scale, that is pointing towards the issue about the state's attorney. I give you points. But on the issue of a punitive cost order, that is a totally different kettle of fish. So you can't liken the two.
In paragraph 41, if we're imprecise, I think in paragraph 41, we say we're seeking a personal cost order against Mr. Zuma payable by him.
By him, yes. Not punitive.
Well, I respect it.
I think we still have an opportunity to ask for costs in full on the attorney-client scale. That is on the basis of the alluvial creek principle.
Yes.
1929 in the UK.
In fact,
The object of an award of attorney and client costs is not to punish. It's not punitive in nature. It's to compensate. If the litigation is of an excessive effect. So, the question is, can the court mirror a motive when you haven't sought? Well, I don't know.
we have
paragraph 40,
said
paragraph 40 seems to me to indicate that the state ought not to bear those costs.
the taxpayers are not to bear the cost.
And that's
the
what you're
link.
turning time, not to punish, but to compensate the state.
That's the link that Justice Jones seems to be uncomfortable with. And that's a link we are making, that the taxpayer, because that is the essence, that is the motivation for asking for costs, not on the ordinary scale. That the taxpayer should not continue to pay.
But I can't dictate that FNB mustn't pay your cost when you go for a loan from FNB. I can't say FNB can't pay it.
And in paragraph 46, two of our look, I can't do it. But I give it.
Thank you very much,
Court, I will be absolutely brief. Why are we here? This morning we were able to persuade the court that to grant the applicant leave to intervene for the purpose of being able to apply for leave to appeal in the application. I honestly do not understand the question of delayed application for leave to appeal. The first time that the applicant is able to speak about leave to appeal is when he is joined. He's joined, he's now a party to the case. He's now able, he's got standing to now stand before the court and say, can I now be allowed to appeal the judgment or the order to a further court? So I'll stand with what my learned leader said in respect of the grounds on which, if there should be a basis on which there should be condemnation for the late filing of the application for leave to appeal, I suppose, then I stand by what my learned leader submitted in his address. Second issue, the question that must bother the court's mind is whether or not it was correct for this court to hold that Mr. Zuma, co-president, had acted so recklessly and in such an unreasonable manner that he ought to be punished with a cost order. That is the real issue. When the court inquires into this question, it will look at objective facts that support a finding of recklessness. Objective facts that will support the notion of unreasonableness. But let's go to the issues that were raised in the review application itself. The court could never say that the issues that it had to contend with are insignificant constitutional issues that do not require a judicial resolution. Could never say that. Whether or not it is competent for a remedial action granted by the public protector to direct the president to appoint a commission of inquiry is one aspect. Whether or not the public protector can go as far as directing how that commission of inquiry should be exercised is another. It should bother the person who must exercise that power. That is it, because that power is a constitutional power. When in doubt, what should the president do? When in doubt about what the constitutional implications of a particular order that has been directed at him, when in doubt, what should he do? Where should we go in order to resolve that question? He tells us in his affidavit. He says, firstly, I read the report. I consulted my lawyers. I got advice. I was told I was good to go on a review. How can that be regarded as recklessness? When a constitutional functionary says, I'm uncertain about this order that I've been asked to exercise. So all that we're asking is the opportunity to deal with the finding of the court that there was recklessness in bringing the application. I mean, the court goes as far as saying this was, Mr. Zuma should have known, a non-starter, that he should have known that this was a non-starter. My learned leader referred to an issue I do want to deal with because it's been distorted a great deal. The issue of conflict. The court says, you're conflicted. You can't exercise that power. So the public protector is correct to take that power away and give it to the Chief Justice. No, that is a worrying remedial action. It should concern us. Because what it essentially means is that apply that same principle within a court context, where a judge is said to be conflicted. Would it be competent for that judge to surrender, to step aside, and for a Minister of Justice, for example, to take over the function of a judicial officer? It wouldn't be. So it's not competent. And even if the court has found that it's competent, we would say it was a matter, as a legitimate concern that the president would have had, having taken legal advice. It was a concern, because what it essentially meant was this, that if the president is now faced with two judgments. One judgment says, if the president is conflicted, he can't appoint a functionary that he is constitutionally obligated to appoint. He would have to defer to his deputy, but it's still within the executive. it is still within the executive, and as court put it in that matter, the corruption matter, the corruption matter. The president would be absent by virtue of having been conflicted, and therefore the deputy president would step into the shoes to exercise that particular constitutional power. But there is no anomaly there, because the person who exercises that power has the constitutional power to do so. It's different. Here, what the particular says is this: appoint a commission of inquiry. He was conflicted. Why should the principle established in Corruption Watch not apply in this particular case? And this is the quagmire a constitutional body or person finds himself in. In one moment, he can defer to his deputy because that is within the executive, and the executive can exercise that particular power. In another, what happens is a power solely reserved for the executive is given to the judiciary. It's given to a member of the judiciary to exercise. And why is that not a weighty issue for a president seeking to implement that particular remedial action? It is indeed a weighty issue. And it concerned the court, because with commendable clarity, the court went into detail dealing with each and every constitutional issue that had been raised in that review application. It never once dismissed these constitutional questions that were raised in the review application as frivolous, as without merit, in the sense that they should have been obvious to any person. They went into detail dealing with those issues and providing clarity where none seemed to exist. The question we ask simply is this: why is that recklessness? The president says, I received the report, I read it, I then asked for legal advice, I then was told, through legal advice, to go and review the application. What else would the president now English is disappearing, and perhaps I should come down a little bit. What else would the president have done but to do exactly that? That's a responsible exercise of a constitutional function. You are uncertain about what to do, you ask the lawyers to do it. If lawyers give you an advice, you say, guys, I mean, this is what you've given me. What should I do? They say, no, man, Mr. President, there is a constitutional anomaly here. You need to get it. You need to get clarity on the issue. He then comes to court, and he raises his concern. It should not likely be dismissed. That process of thinking towards how to litigate a matter is what everybody else does who wants to exercise that obligation responsibly. It's an astonishing proposal. It may have been part of the suite of options that the president could have had, but it's astonishing for one reason. When the president comes to seek a declaratory order, wouldn't he have been criticized for exactly the reason why he's been criticized now? You are coming to seek an academic. You've already implemented the findings of the public protector. What is it you're clarifying? You've already done that. You've already complied with it. Why are you now going this route? But the reason why it's also an astonishing submission is this. Let's assume kind with the proposal that Mr. Barnett gives. And the court agreed with him in his declaratory order. What then? If the court found, for example, that the public protector couldn't do that in its declaratory order, then what? The Constitution says something about that. You issue a declaratory order. The consequence of the declaratory order in the events, for example, the court found that the public protector couldn't do it. The consequence of that declaratory order would have been invalidity. It's not just a mere clarification point, because it involves questions of constitutional importance. You couldn't simply be saying the public protector has no power to impose these kind of restrictions on the president's power, but say that simply as a declarator, it doesn't have that, and say no more. It would have to go further and say, and therefore, such an order, an order would be invalid. But then, what credibility would that give to the commission that has started to investigate these weighty principles, these weighty allegations of fraud and corruption and state capture? The commission, under the weight of that order of declarator, would have had to function on the basis of a cloud of uncertainty. Now, assuming a judge was sitting in the matter as they do now, and they're faced with a declaratory order that says, well, we are not entitled, the Pope was not entitled to impose these restrictions on a president relating to how they are appointed. How does a judge who is sitting in that commission feel comfortable that they are operating a commission of inquiry that is consistent with the law? It wouldn't be. So the suggestion that my learned friend makes is a novel suggestion, but it may well have been part of the suite of suggestions that were given to President Zuma. I'm not suggesting it was, but it may well have been one of those proposals that could have been thought of. It wasn't. What was thought of was this. Firstly, because there is constitutional uncertainty that is not frivolous, that is not powered by a personal interest, but a genuine concern with whether or not another functionary examining certain facts can direct the president to perform a constitutional duty in a particular way. That's something that cannot simply be dismissed as being reckless. Can I then deal with a judgment that my learned friends for the EFF happily raised in their heads of arguments, but I see in their bundle of papers they omitted to attach it. And this answers a question that was constantly asked, which related to the test in appeals that relate to costs. Those arguments have been made by my learned friend. I want to address them. I simply refer to this judgment, which is referred on page. Sorry, it's a judgment, Limpopo Legal Solutions versus ESCOM Holdings. And I believe it's in paragraph 55 of that judgment. You'll see in that judgment, Honorable Court, you'll see when it looks at that judgment. This is the first sentence of the Constitutional Court dealing with an appeal that related to punitive costs. It says the first applicant, Limpopo Legal Solutions, is no stranger to litigation in this court. In the context of punitive costs. The court was looking at punitive costs. In such circumstances where the litigant... Yes, I've got, the references in the heads of my learned friend. Could I just help myself to your heads? Are these your heads? Mm. Yes. You've got it. Oh yeah, the reference is 2017 12. Volume 12, BCLR 1497 CC. I start with the first sentence of that judgment, where it says, this applicant is no stranger to litigating in this court. Sounds familiar? In the past year alone, it has launched no fewer than 5 applications for leave to appeal. Sounds familiar? And then one goes into the facts of the case. There was clear recklessness, no doubt about it. In one instance, ESCOM informed this particular applicant that they were on site fixing the problem, the electrical problem that they complained about. in a particular township. They said, please hold on your application to compel us to do this, because we are on site. We are seriously looking at it. We are resolving it. He refused. He did not disclose that to the court that he had been contacted by ESCOM. He went ahead and got the order. When the Constitutional Court dealt with the issue of costs, this is what it says, and it starts at paragraph 20 of that particular judgment. In fact, it starts nicely at paragraph 19, and it starts by saying, but what of the cost order? Then it says in paragraph 20, a cost award, of course, falls within a court's discretion. An appellant tribunal cannot willy-nilly intervene. The grounds for interference, and then they refer to a summary in the Campepe judgment, and then they go to Biowatch in paragraph 22. Then they said Biowatch fundamentally clarified the nature of costs in constitutional litigation. The general rule is not to award costs against unsuccessful litigants when they are litigating against state parties and the matter is a genuine constitutional import. The court recently explained the reason to avert the chilling effect of an adverse constitutional order. And let me just pause a moment here and deal with the adverse impact of a of a punitive cost order that is granted against the president. So every time a president gets a matter that implicates his constitutional powers, must examine it and must give it to, it must run through the process that it usually runs. Legal advisors, counsel sometimes gets involved, opinions are granted, and they must get legal opinion, legal clarity on what those issues are. But in circumstances like these ones, where the process was followed, but despite that process having been followed, the president was found to have been reckless. That is of concern. It would have a chilling effect on this constitutional functionary to exercise those powers without any fear or favor. So the chilling effect is quite profound because it freezes, it could have the effect of freezing a president into indecision. Because the decision, the president doesn't know, should I seek clarity from the courts or not? Because if I seek clarity from the courts on the basis of legal opinion I've got, I'm likely to be accused of being reckless. And I'm likely to pay for my own pocket. That would not be a desirable development in how public officials are dealt with. I know the trend that the courts are beginning to emphasize, that public officials who act recklessly ought to, and I'm in favor of that. But here, can we say that someone who got legal advice, and that's not controverted, who got legal opinions, and came to court on the basis of that, acted recklessly? How else could he have acted? I've just shown the option given by my learned friend doesn't exist. It couldn't be the right option because it would have unbelievable consequences for a commission appointed under the cloud of a legal challenge to the validity of the public protector's own remedial action. So coming back to this case, and the court will have, if it does have regards to this particular court, and urge the court to do so, will find in paragraph 35, going onwards, that the court dealt with the punitive cost orders. And it explained a number of things. It is the conclusion I'm interested in, which is in paragraph 42. The conclusion says, just a paragraph before the conclusion, which is paragraph 41, although Biowatch changed the cost landscape for constitutional litigants, it gives no free pass to cost-free, ill-considered, irresponsible constitutional litigation. The applicant seeking to vindicate constitutional rights must respect court processes. The first applicant has embroiled itself in litigation since its inception in 2016. A more considered, cautious approach would be helpful all round. If we stop there, we could take this court's decision on the cost and put it right underneath. But lo and behold, it doesn't. The Constitutional Court does not follow that particular line. What it does, it says a cost award in paragraph 42 in constitutional litigation raises constitutional issues. In the High Court, the applicants sought to invoke constitutional prescripts against ESCOM, a state party, though they were unsuccessful. In an unprecedented departure from the general rule, the High Court granted a punitive cost order against the applicants. Although the applicants, in the manner in which they concluded their litigation in the High Court, themselves authored the punitive cost order in that court, their application in this court was not frivolous or vexatious or manifestly inappropriate. Buyer watch must therefore apply before this court. Each party must pay its own costs. This is where it's very important for this court in considering whether or not I will deal with that, Mr. Siveza. This court, in looking at this particular judgment and how it can be applied in this particular case, must examine the fact that the issues that were raised by former President Zuma were not frivolous issues. They were weighty constitutional issues. They will dog this country for a long time. What the extent should be of, or let me rephrase it, the permissible and constitutionally sound approach in dealing with constitutional uncertainty. And the court, I can say this boldly, was quite wrong to say that this was an obvious case. It committed a commendable amount of detail in dealing with each and every ground of review. These were weighty constitutional issues. They were not frivolous issues. And while he now seeks only to vindicate the cost order that is at play, the constitutional issues that remain there are very important for the future of the next president. Well, the incumbent now must always ask himself, when he's faced with the situation where he's told, I can't appoint this particular ambassador, because this ambassador has said some things about certain people that are not right. Or because you are conflicted. He must engage with that issue and say to himself, okay, fine, how do I engage with this issue? Because the power to appoint an ambassador is mine. And how do I engage with it? If I go ahead and appoint this person and it's challenged, it will be regarded as an act of constitutional recklessness, attracting a cost order that hits his pocket or her pocket.
I think we emphasize the point from a number of angles, but the issue is context. That's the issue.
The issue is context. I have no other context other than the one that is in the papers. President Zuma says, I got the application, the remedial action, I engaged with it. I had concerns.
Why does it say I can appoint a judge? Does it pay?
Why I can't appoint a judge?
The remedial action was clearly crafted to say, in our investigation, we've come up with
Yes.
and for that reason, you know the right person to do this. You still exercise your power to appoint the commission.
Let me answer that.
The judge. That's what I'm saying.
Firstly, let's function from a presumption that judges are always impartial, irrespective of who appoints them. Let's just dispel this notion that when he has appointed a judge, this judge will go and do his bidding. That would be, if we were to work from that presumption, which is a presumption widely accepted in the courts, the presumption of integrity, a presumption of impartiality and independence that is accorded to judges. Doesn't matter what the president thinks or who is appointed. President says, I'm appointing so and so as a judge to chair this commission. The responsibility to use the weight and the authority of the office of a judge lies with that judge, not the president. Not the president. I have a difficulty with this notion that when the president appoints judges, he should have no view about it. There should be some independent. It should be so independent as not to have a view about it. But the responsible functionary to exercise the authority of a judge is the judge who is appointed. And it's based on a principle that is widely accepted. Judges remain independent, irrespective of who appoints them. I know the public perception that a judge who has been appointed in these circumstances may attract. But here is the quagmire. The public protector has no constitutional power to reassign constitutional duties. The constitutional duties are completely entrenched in the Constitution. She has no power to reassign them. In other words, she cannot take from the president what belongs to the president and give it to the judiciary and say, judiciary exercise this power. And I can understand the Corruption Watch case where the court said, fine, you are conflicted, but what we would say to you is, this is not insurmountable. Someone within the executive can easily step into your shoes. But to be told to borrow the authority of another organ of state, another arm of government, that arm of government which has no power to appoint a judge to do so. And we can say whatever we say about selecting a judge or whatever. He had no choice. In terms of the order, the judge that was presented to him by Chief Justice was the judge he would appoint. He couldn't say to the Chief Justice, no, not this judge. He had no choice. He was bound by that particular. If he had to implement that, he had to implement that. But there's a more concerning question. Does the Chief Justice or does the judiciary have the power to appoint judges over commissions of inquiry? They don't. The Constitution is clear on that. And so, dealing with public perceptions requires that we do so in accordance with the rule of law. So it doesn't matter that the public thinks that there should be a death penalty, or that the public thinks that people who commit certain crimes should be shot on sight. The rule of law demands, it's a rigorous principle. It demands that there is unwavering, uncompromising compliance with it. That's what holds us together. That's what gives comity to different arms of government. To different arms of government, they're able to say to each other, we are going to respect each other's space. We as the executive can't interfere with what the judiciary says. Similarly, the judiciary can't interfere with what the executive says unnecessarily. So with respect, this is not a case where the court found that President Zuma's approach to the courts, not anywhere else. He couldn't go anywhere else. He didn't go to parliament, he came to the courts, where that judicial order would give clarity to a constitutional concern he had. It could never be said that that particular decision was wrong. That was a wrong approach. On the issue of parenting, firstly, it's doubtful that preemption applies elsewhere other than a court compliance with the court order. And it's understandable why. It would apply only where someone unequivocally, without any doubt, says, I am complying with the court order. Because the dignity of the court has to be respected. And if someone articulates that in a public domain and says, yeah, no, I'm complying with this court order, there is no room to come back and turn around and make another statement. Because that's the essence of parenting, is that it is a principle that upholds the dignity of the courts. But that principle of preemption is not entirely without restrictions. It too, potent as it is, must bow down to the principle of legality. If, for example, there were to be a situation where court say Parliament couldn't exercise its legislative function? And the Speaker, speaking on behalf of Parliament, said, no, we've been told that we can't exercise our constitutional functions. It would be untenable to come and argue that preemption applies in those instances. Because preemption would be invoked in order to hold a position that is unconstitutional and that is in consonant with the principle of legality. And let's hold the principle of legality as ultimate principle that must govern how we exercise constitutional functions. So, when the President says, I will appoint a commission of inquiry, but I have concerns with how I've been directed to implement that particular directive. And those are the concerns I'm seeking to get direction from the courts. Nowhere else, not Parliament, nowhere else. I'm coming to court because I have uncertainty about this issue. He's acting correctly. He's acting very responsibly. It can never be suggested that when he assures Parliament, which is concerned about this grave looting of national resources, he cannot be faulted for saying, I want to appoint a commission of inquiry. I want to, but I have concerns with this constitutional principle that I'm being directed to exercise. And I just need legal clarity. Because, Honorable Court will know, the President had not taken that position and simply appointed the Commission of Inquiry on this without testing whether or not his powers could be truncated as they were by the Public Protector's findings. It's possible that PASAC, being a constitutional body with constitutional interest, would have said, no, wait a minute. How can it be that a public protector tells a Chief Justice what to do in order to assist the President exercise his power? We're concerned about the integrity of the Constitution. We want to test this aspect. So I'm saying, and I say this with respect, a lot is said about this particular applicant. Just ignore that. Look at it, but on this case, this particular case, not other cases, this one. What does a reasonable president do when he is faced with a constitutional uncertainty? What does a reasonable president do? Even if you were to, let's say for example, there was a decision that had to be made whether he had to declare war because Lesotho had decided to invade South Africa. And the president said, no, you know what? I do want to get advice from the military, I want to get advice from intelligence, I want to get direction as to how I should exercise this power to engage in this war. And he decided, no, I need to test this aspect with the courts because I'm uncertain about a particular aspect that would allow me to declare war on another country. But meanwhile, there is hostility right at the borders. The public would be saying, guys, we can't allow this to happen. But the president would say, and he must, where there is uncertainty, not bow to public pressure and say, because there is a circumstance that is alarming, I must ignore what the Constitution says about my powers. I must just exercise them. It's like asking the court to say, because there's so much crime in the country, let's go beyond what the law says about punishing those that are found to have committed crime. Let's hang them. The court can't do it. It doesn't matter what the public says. It doesn't matter how many rallies are held in this country to suggest that a death penalty must be imposed. The court must be resolved and stand on the principle that was enunciated in the Mokwanyana judgment and uphold that particular principle. So what would the appeal court be asked to determine? The appeal court would simply be asked to determine whether or not this court was correct to say that he was reckless. Either based on the principle of preemption, which we say it did not apply in this case. This case was nothing to do with preemption. The fact that the president says, I am going to, and bear in mind the nature of the remedial action itself is open to changes. The public protector can re-engage with it and say, I'm going to modify this aspect of the remedial order that I've given. Because he can re-engage with the findings that he makes. He can negotiate with the parties against whom that finding is made. So, if the court does say it has attributes of a court order, with respect, it is none, other than that it's binding. A court order in terms of 164, 165 of the Constitution is binding. Not a remedial action of the public protector, it's binding, but it can be reviewed and set aside. And according to the Constitutional Court in the effect matter, the Chief Justice says, yes, well, if you have concerns about certain aspects of the remedial order, then of course raise those and deal with them. So, we will submit, Honorable Justices, that when you have granted us leave to intervene, you go further and grant us leave to appeal. Because you will be pleased you did so. When a fundamental issue relating to how a president or any functionary that is occupying because then of course this president now must worry about how he exercises his own powers, and it should never happen. There should never be something circulating in the head of a president about the possibility that if he goes to court to ask certain questions to be answered by the court, that the court is going to mark that president with the punitive cost order. I urge the court to look at the judgment I referred to, because in that judgment, it will find that it's actually on point on the issues that we seek to argue. It's on point because you will not run away from the fact that these were constitutional issues, weighty constitutional issues involving a constitutional body, a judiciary, and the executive. How those should intersect in meeting national challenges. And so this was not a frivolous or vexatious or self-serving position that he brought. He was not coming here to say a commission of inquiry should not be established. He was saying, please tell me that I should establish lawfully. And I have concerns about this directive that I've been given. And the court answered it. Once the court answered it, the commission is running. And right now, the Deputy Chief Justice can be comforted by the fact that he has the authority of a court order to run the commission. There are no legal uncertainties about it. Even though we have, in our own space, concerns about the constitutionality of the constitutionality of what happened. It's water under the bridge. It's there. There is a court order. It's not been reviewed or set aside. It's not been appealed. So the chairperson of that commission can stand on the authority of that order and say, I am here with no constitutional questions hanging over whether I'm doing legitimate commission or not. So these issues that trouble this country of state capture, corruption and fraud are dealt with. They are going to be dealt with now. And whatever concerns they may have about the president trying to sweep things under the carpet, it's now in the open. It's on TV every day. We would ask that you grant leave to appeal. As far as cost orders are concerned, we would simply ask for the cost to follow the course. And as far as the punitive cost order is concerned, as I said, Justices, it's important not for the court not to perpetuate the idea that a punitive cost order is a norm, where particular litigants are concerned. They have views about President Zuma or former President Zuma, but it's not right to come and say we're giving him cost orders because he has litigated elsewhere. He's been found to have done this elsewhere. Let's look at this case. did he irresponsibly exercise his constitutional power to inquire from a legitimate constitutional body whether or not he could do this? And the answer should be no. And this court should have found that. And we say another court, granted the opportunity, will not say that in his qua-president he acted wrongly or he acted recklessly in having concerns about whether or not he could exercise the power as directed by the public protector. If there are no other questions, I have nothing else to add other than to move for that order.
Maybe you should tell us your secret by having so much energy at the end of the day.
The secret, I don't want to share it with my friends because then it must remain with me.
Thank you.
Yes, thank you, Chief. Thank you, Chair.
JP,
Advocate Zameta, I think we're done.
we are done, JP. As I hand up the memory sticks that the court had required, I just want to indicate to the court that the appropriate course order, if they succeed, should be course in the appeal.
Well, can I then also indicate that's the same thing. Yeah.
We are going to reserve our decision. I'm sure you don't expect us to make it out now. We need to consider, and we promise not to take very long. And then we will come back and advise you all when we're ready. But thank you to all the legal teams here for the submissions made. Very helpful, very helpful. Thank you very much.
All right.
It's the best time we have. It took time, yes, no. That's the thing about it. It doesn't matter, that's like, I don't know.
There's another matter here. Looking on this. No, but you are saying it.